The Speaker.
Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste.
Oath or affirmation, announcements by the Speaker.
Honorable members, I have received communication from the Honorable Shamfa Kaju, MP, member for Tobago West, who has requested leave of absence for the period December 10th to the 15th, 2019. The Honorable Kamala Prasad Bisesa, SC, MP, member for Superior, and Dr. Lakram Bodo, MP, member for Faizabad, who have requested leave of absence from today's sitting of the House. The leave which the members seek is granted.
Bills brought from the Senate, petitions, papers.
The Attorney General.
Speaker, I have the honor to lay the annual report of the Legal Aid and Advisory Authority for fiscal year 2014 to 2015.
The Minister of Finance.
Thank you, Madam Speaker. I have the honor to lay the Financial Obligations Amendment Regulations 2019.
Reports from committees.
Member for Ruka Maloney.
Thank you very kindly, Madam Speaker. Madam Speaker, I have the honor to present the following reports. The interim report of the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018 in the 5th session, 11th Parliament. Thank you, Madam Speaker.
Prime Minister's questions.
Member for Caroni East.
Madam Speaker, Honorable Prime Minister, could you state the total amount of the judgment award, inclusive of legal costs to be paid to the UK-based Cobham Helicopter Services Limited, with respect to the termination of the Air Guard's helicopter maintenance and technical support contract, which your administration entered into in 2017?
Prime Minister.
Madam Speaker, this question requires a certain amount of research, and 20 minutes could not do the question justice. However, I give my colleague the assurance that if he files this question with the appropriate notice, a comprehensive answer can be given at the next sitting of Parliament.
Member for Caroni East.
Yeah, I appreciate that, Honorable Prime Minister. I just want to jog back your memory. Could you remember at what time this contract was entered into? Because I think you were part of the government when this was done. If you can't, well, I'll wait for your answer when I ask it. I'm just jogging your memory.
Madam Speaker, I don't think my colleague should try to jog my memory, because my memory will take a lot of jogging. This goes way back to the cancellation of the OPVs and the contracting of the purchase of the helicopters. From the time the helicopters were purchased, the maintenance contract would have kicked in. And if your memory is jogged, you may remember it is not my government that canceled the contract. But let us wait until next week, and as a matter of fact, you will get a comprehensive answer. And that is the reason why I've asked, and I'm glad that you will acquiesce to that. So next week we'll get the whole story. Member for Caroni East.
Honorable Prime Minister, having regard to the highly speculative and high credit risk B2 and BB minus rating ascribed to TSTT by Moody's and Standard & Poor's respectively, was the government, as 51% shareholder in TSTT, required to provide a guarantee for the company to borrow $2.7 billion via its recent 8.87% 10-year bond issue? A very
Prime Minister.
important question.
Speaker, the business of TSTT does not require a government guarantee.
Supplemental. Member for Guaranese.
At all possible, indicate who would have stood this guarantee. Is it TSTT itself?
Madam Speaker, TSTT in its corporate business and its internal banking arrangements would have done that and did not require a guarantee expressed by the Minister of Finance.
Supplemental. Member for Guaranese.
Would you indicate whether you're aware if a note came to Cabinet via the Minister of Public Utilities on this issue?
Prime Minister.
Madam Speaker, a note would have come to Cabinet well in advance of this date or this particular issue, where TSTT indicated a strategic plan. And in that strategic plan, it would have indicated how it intended to proceed.
Member for Naparimo.
Speaker, could the Prime Minister inform this House which company printed the new polymer $100 bill?
Prime Minister.
The polymer $100 bill would have been printed by the same company that normally prints our money and has been doing so for the last 20, how many years? For decades, I shouldn't do. That company is Delarue.
Supplemental. Member for Naparimo.
Could the Prime Minister indicate when the order was placed?
Prime Minister.
I couldn't, without consulting the files, indicate, but that order would have been placed a long time ago. I couldn't give you the exact date on short notice, but the order was placed by this government, so it would not have been, it would not have been your senatorial colleague. It was placed by this government, and it was placed in 2019. But the intention to place the order would have been, in fact, just to put my colleague at ease, this process, as a national security process, would have been initiated in 2017. The first pieces of correspondence would have appeared in 2017, and the actual placement of the order after preparation and discussion would have been many months ago in 2019.
Member for Naparimo.
Thank you, Madam Speaker. Could the Prime Minister inform this House of the cost of printing the new $100 bill?
Prime Minister.
Madam Speaker, the cost of printing our money is a national security matter and will remain so. What I could tell the member is that the cost of this bulk purchase, the unit cost would have been cheaper because normally bills are printed in increments, in tranches, and this large tranche would have resulted in a lower cost per unit.
Member for Point Appeal.
Thank you, Madam Speaker. To the Honourable Prime Minister. Prime Minister, can you provide an update into the status of two major projects which your government committed to the people of Labrie, namely the construction of a $200 million plywood factory announced in 2016 and the construction of a dry dock facility announced in 2018?
Prime Minister.
In our quest as a nation to diversify our economy, we are constantly looking for new opportunities, new openings, new possibilities. With respect to the plywood as a possibility, that was raised as a possibility and not a project. It was examined and found not to be viable, to be pursued, and has not been pursued for many reasons, not the least of which was a new development with respect to the whole environmental aspect and safety of the plywood business. Secondly, the dry dock work continues apace to get to a point where we can have an investment decision, but that work continues, Madam Speaker.
Supplemental member for point of order.
Thank you, Madam Speaker. The Honorable Prime Minister, in the second body dry dock facility, could you give us a status of what is the status or percentage of where we are with the dry dock facility?
Prime Minister.
Well, Madam Speaker, the dry dock facility, what we were committing to, what we still are committed to, is an investment. We're working with a Chinese company, and we got to the point of getting agreement on a percentage shareholding of investment. As to which company is going to do it, we've had some changes on that, and we're still working through that through diplomatic channels, Madam Speaker.
Member for point of order.
Thank you, Madam Speaker. Honorable Prime Minister, could you give the status of Mr. Mike Wiley at Heritage Petroleum Company, and if the former CEO is still receiving compensation from the said company, which is Heritage Petroleum Company?
Prime Minister.
Madam Speaker, the former CEO of Heritage, Mr. Wiley, has had his contract ended, so he's not on the payroll, but the matter is with lawyers where they're seeking to come to an amicable agreement with respect to the discontinuation of his contract with Heritage.
Supplemental member for point of order.
The Honorable Prime Minister, supplemental, could you give us a figure of what that is outstanding, or what the agreement as far as the compensation for Mr. Wiley?
Much as I would like to facilitate my colleague, I'm not in a position to do that, but that's a matter which is internal management to Heritage, and if there's some notice, we might be able to. But since the matter is being discussed in some element of arbitration, I expect that we'd be hesitant to answer the question in that way. When the matter is concluded, that information could easily be made public.
Member for Naparima.
Thank you, Madam Speaker. Could the Prime Minister update this House on the status of investigations into the Daryl Smith affair, particularly in the light of statements by a member of the investigative committee accusing two senior cabinet members of misogyny?
Prime Minister.
Madam Speaker, the government, through the Prime Minister and the Attorney General, have spoken publicly on this investigation and its status. The investigation status is that a report has been done from the investigation, and legal advice obtained from at the office of the Prime Minister and at the office of the Attorney General indicated that the report, by virtue of its nature and its process, could not be used in the public domain. The report was in the hands of the Permanent Secretary Office of the Prime Minister, head of the Public Service, and that office was also constrained by this legal impediment. And with respect to misogyny, you said? I presume misogyny. I know of I know of nobody in the cabinet that is guilty of misogyny, Madam Speaker.
Supplemental member for Naparima.
Does the Prime Minister not think that the appropriate body for doing this investigation is the Police Service of Trinidad and Tobago? And could you indicate
One question at a time. Prime Minister.
If you can indicate what law is broken to be filed with the police, then maybe that might make some sense. A report that is not legally sustainable, a report that is not sustainable would not give the police a position on it. This thing has been discussed at length. I don't know what you'll tell the police. That is different to what we've told the public.
Supplemental member for Princestown.
Thank you, Madam Speaker. Honourable Prime Minister, in light of the answers that you've provided, could you indicate, in your estimation, what is the next step in terms of bringing this matter to a close?
Prime Minister.
Madam Speaker, as Prime Minister of Trinidad and Tobago, I had a reason to be dissatisfied with the actions in a ministry and the actions of a minister with respect to the termination of employment in that ministry. As Prime Minister, I have done the ultimate, which is to dismiss the minister. And of course, as far as I am concerned, that is the end of the matter. I do not have any authority to do anything else on that matter. With respect to any other aspect of that matter, the report which sought to investigate further nuances of the report got to the permanent secretary, head of the public service, and that is where the matter is. So if there are opportunities for other matters to be dealt with, it has to be done through the office of the permanent secretary, and as far as I am aware, the permanent secretary is not in a position to use any report which the legal advice indicates is not useful. And all the information surrounding that matter is in the public domain, having come from the relevant stater, the office of the Prime Minister, the Attorney General, and in fact, the permanent secretary.
Member for Naparimo.
Madam Speaker, was the Prime Minister aware when he addressed the House last week on the Unipet matter that the state had owed Unipet considerable sums of money, thus affecting Unipet's ability to pay Pariah Fuel Trading Company Limited for fuel supply?
Prime Minister.
Madam Speaker, I had no involvement in Unipet's financial status when I addressed this House last week. I addressed an issue on the simple note that Unipet is required to pay Pariah for product made available to Pariah. And that is as far as I am aware and I'm prepared to go. From Unipet's requirement to pay Pariah is not conditional, as far as I am aware, on what other agencies of government owe Unipet. Those are completely separate matters.
Supplemental member for Naparimo.
Is the Prime Minister given to commenting on matters where he's not fully apprised of all the information and going on to
A member for Naparimo, I'm not going to allow that question. Member for Carinese.
Honorable Prime Minister, would the government be prepared to allow Unipet to import their own fuel by themselves, privately, or any other petroleum company to import their fuel on their own without going through NP and so on?
I'm not going to allow that question arising out of what has already been discussed there. Member for Naparimo.
Could the Prime Minister inform the House of the quantum owed by National Petroleum Marketing Company to Pariah Fuel Trading Company Limited as at November 30th, 2019, or at the latest date for which said data is available?
Prime Minister.
Madam Speaker, NP has paid all its non-subsidy amounts for September and October and has paid approximately $500,000 towards the not yet due November bill. $321,937,441 would be the total due for November. And, well, it's not yet due.
Member for Naparimo.
Could the Prime Minister inform this House if and when the Campaign Finance Reform Bill will be introduced and debated in both houses of Parliament?
Prime Minister.
Madam Speaker, this government does not deal with if and when. We made definitive statements and commitments were made that this government will bring to this House campaign finance reform. And, Madam Speaker, the government has spoken publicly that we have draft legislation in readiness to bring to this House. We have a legislative agenda, and that piece of legislation will take its place in that agenda in the very near future.
Supplemental member for Naparimo.
Prime Minister indicate some time frame in which it will be brought to Parliament in the context of the next general elections.
Prime
I
Minister.
just did. I said it's going to take its place in the scheme of the legislative agenda, and that was said against the commitment that it will be done. This government has has committed to do it. This government is saying that the legislation is advanced and would be in this House in the very near future, and it will come to the House for treatment in the very near future.
Supplemental member for...
Can I take it then, Prime Minister, that it will come before the next general election?
I'm not going to allow that. I'm not going
Do you
to
know
allow
when the
that.
next general election
Prime
is?
Minister, I'm not going to allow that.
Urgent questions.
Member for Couva South.
Thank you very much, Madam Speaker. To the Minister of Finance, could the Minister inform this House if the owners of businesses can deposit old $100 notes realized from transactions on the 31st of December 2019, excuse me, on the next banking day on the 2nd of January 2020.
Minister of Finance.
Thank you, Madam Speaker. Madam Speaker, this matter and other related matters currently form the subject of discussions between the Ministry of Finance, the commercial banks, and the central bank. And the three groups or three entities are looking at the various options available to deal with whatever old banknotes are presented on the 31st of December. I don't know what you're putting up your hand for. I haven't finished speaking. Madam Speaker, what I would say right now, the deadline for cancellation of the note is December 31st, and the Ministry of Finance, the central bank, and the commercial banks are in discussions as to what can be done to accommodate especially retailers and business owners who would have significant quantities of cash in their possession after the Christmas shopping between the 27th of December and the 31st of December.
Supplemental, member for Couva South.
Thank you, Madam Speaker. Could the Minister of Finance tell this House if doubles vendors, Sahina vendors, Polori vendors, fishermen, those who cut grass on the 31st of December and are not owners of legitimate or registered businesses will be allowed to deposit their income realized from transactions on the 31st of December 2019 into their accounts on the next banking day, the 2nd of January 2020.
Minister of Finance.
Thank you very much, Madam Speaker. The whole question as to what is done with what is referred to as the unbanked persons without commercial bank accounts, persons who are in the informal sector, that is all being discussed between the commercial banks, the Ministry of Finance, and the central bank. I would expect if someone does provide services on the 31st, they may very well get the new notes. But all of these things are under active discussion. Even before I came to this House today, a few minutes before I entered the chamber, I was in discussion with the Governor of the Central Bank to see what was the current position with respect to your urgent question as to what businessmen would be doing with the cash they would have at the end of the year and so on. So all of these things are being actively discussed on a daily basis. These are real-life situations, and we are seeking to provide real-life options to them to minimize the inconvenience to the public.
Supplemental, member for Caroni East.
Honourable Minister, since you, by virtue of the legislation we passed last week, where you can direct the central bank as to the closing date for all this business with the $100 bill contract issue, what is your position as Minister of Finance on this matter in the negotiations with the Bankers Association and the Governor of the Central Bank? What is your position as Minister of Finance?
Minister of Finance.
As a current and loyal member of the Cabinet, I am guided by the Cabinet, And the Cabinet has taken a decision that the date of cancellation would be December 31st, 2019.
Member for Naparima.
To the Minister of Health, is it the case that patients now have to wait days to access beds in the nation's hospitals because of the numbers with flu symptoms?
Minister of Health.
Thank you very much, Madam Speaker, and thank you, Honourable Member, for the question. The best way to answer this is to give some statistics. The cases of suspected flu from 2014 peaked at 7,118. Because of this government's aggressive vaccination drive, we are now in 2018 at 4,515 suspected. 2019, up until December the 6th, we have 3,232. In other words, there's a more than 50% decline in the cases of suspected influenza cases being seen. That will translate into less demand for hospital beds. What I can tell the Honourable Member is this. There was a peak in November for about 2 weeks when the influenza virus, inclusive of H1N1, took its toll. That peak has since declined significantly, and we are now in a much better place than we were 2 weeks ago. What I could also tell the public is that I am concerned that the message for vaccination is not getting through to one particular group of people. That is the number of deaths being recorded amongst the East Indian diabetic population in South Trinidad with comorbidities like diabetes, hypertension, obesity, and who are smokers. The majority of those deaths, unfortunately, fall into that category, and the majority of them are unvaccinated. The other major group I am concerned about, because I got some data yesterday, only 217 pregnant women have availed themselves of the vaccination. That is another area of concern. So I am appealing to the vulnerable groups, the elderly, with diabetes, hypertension, obesity, smoking, get vaccinated. I'm also appealing to the pregnant population because that rate of 200 uptake is abysmally low. And I will appeal to all in the vulnerable groups, children 6 months to 5 years, the diabetics, those on immunosuppressant drugs, the asthmatics, those suffering from constructive pulmonary disease and so on, to get vaccinated. Thank you, Madam Speaker.
Okay. Member for Cuba South. Were you trying to get my attention, or is that you were coughing in your hair? No, I was trying to. Okay, member for Cuba South.
Thank you, Madam Speaker. Minister, could you tell us if there's any truth to probably over 65 deaths at the San Fernando General Hospital, which has been diagnosed as acute respiratory distress, but actually linked to the swine flu issue in this country?
Thank you. And that's a very good question. I developed pneumonia over the past month, and my diagnosis was it was not due to either influenza A, swine flu, influenza B. So it is very possible for somebody to develop acute respiratory distress, example, pneumonia, and die of that not caused by the influenza virus. I am telling the country, I got vaccinated. I got a viral illness. My diagnosis when they did the rapid test was negative for influenza A, negative for influenza B, negative for swine flu, but I still got the virus, the common cold. I developed pneumonia. I could have died, but the diagnosis, the death certificate, would not have shown swine flu. So there are many causes for acute respiratory distress. I must also note it is only this government that is given data on deaths due to influenza. There was no data available in 2013, 2014, and 2015. The death toll could have been thousands. We will never know. It is this government, in full transparency, is hiding absolutely nothing from the public. And to date, the death toll is 32. Thank you very much, Madam Speaker.
Member for Guyanese.
Honourable Minister, are you aware, in your quest for vaccination nationally, which is important, Are you aware that there is a raging controversy globally on the complications of the vaccination programs in young children and even pregnant women as well? And as from the role of a gynecologist, I am still to determine whether I should recommend a pregnant patient for the vaccine, because there's a raging controversy for children and that. And children are getting a lot of complications from the vaccine.
Madam Speaker, if the honourable member has that evidence, bring it to me. I have scoured both local and international publications. I can tell you the chief medical officer has not appraised me of any raging controversy. The raging controversy on vaccination started in the modern era in the 1990s, when Dr. Andrew Wakefield produced a paper linking the MMR vaccine, mumps, measles, rubella, with autism. That was the raging controversy which gave rise to the modern anti-vaxxers and the vaccine hesitancy issue that we are forming. As a matter of fact, WHO, World Health Organization, has called the anti-vaccine movement one of the top 10 health priorities facing the world. And I am very concerned that an eminent obstetrician gynecologist will stand up in the parliament and say he is discouraging his pregnant women from getting vaccinated. I am very concerned.
Member for Caroni. Member for Caroni is Jackie. Member for Caroni East. 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 I would just ask you to please leave the chamber for a couple of minutes, and when you get your set back into a proper, I never said improper, to a proper decorum for here, you're welcome back. Member for Naparima. Member for Caroni East. Member for Caroni East. Just get back to your seat so that I can address you. Get back and sit down so I can address you. Member for Caroni East, I'm warning you that your behavior is bordering on gross misconduct. I am sure you understand the consequences of that. I've asked you to leave the chamber, compose yourself in the manner I expect of you, and you are welcome to return. Member for Naparima.
Minister, if there's a reduction in those experiencing flu symptoms,
just 1 minute.
Could you explain?
Member for Naparima, I'm so sorry. You'll get the time. Member for Caroni East, I'm on my legs and I'm waiting. I'll sit. I will. Member for Caroni East, something must be wrong today. All right? I'm going to sit and you will leave and you'll return. Member for Caroni East. Member for Caroni East, your behavior, in my view, amongst the gross disorder. Your behavior amongst the gross disorder, please leave. Naparima.
To the Minister of Health, supplemental question. If, as you indicate, there's a reduction in those experiencing flu symptoms, then what explains the long wait of patients, long wait including days, to get access to beds?
First of all, let me say, I have no evidence that what the member is saying is true. And the second point I want to make, where was the UNC when they were vaccinating pregnant women in 2015, 2014, 2013, and 2012? There was no quandary then. But because of this government, there is a quandary. There's a raging controversy, according to them. So there is no quandary. When they were in office, vaccinating pregnant women, it is not a problem. We are in office now, it's a problem. It's a raging controversy. Madam Speaker, that is why we use the word patriotism, because this goes out to the international media, that in the parliament it is being said there's a raging controversy about vaccinating pregnant women. I have scoured all the literature. WHO, PAHO, CDC, CARFA, Chief Medical Officer, Director of Women's Health, not one authoritative source has come to me and say people are in a quandary. Right? There is absolutely no quandary.
Would you allow the minister to answer, or should I move on? Would you allow him, or I'll move on? Minister of Health, I'm so sorry that the time is now expired.
Questions on notice, questions for oral answer.
Leader of the House.
Thank you, Madam Speaker. Madam Speaker, there are 3 questions for oral answer, and all 3 will be answered.
Member for Point of Pair.
Madam Speaker, question number 13 to the Minister of Energy and Energy Industries.
Finance.
On behalf of the Minister of Energy, the answer to Part A, I'm advised that Petrotrin's pension plans can meet their obligations for at least the next 20 years. The actuarial valuations for the 3 years ending September 30th, 2019 are currently in progress and would provide more accurate information on the funding status of both plans. These reports should be completed in the first half of next year. With respect to audits, the annual pension plan audits shall commence shortly. Additionally, the Ministry of Finance is in the process of finalizing a contract with an independent actuary to review both plans. This actuarial review is expected to be completed in 2020.
Member for Point of Pair.
Thank you, Madam Speaker. Question number 14 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries. Minister of Finance.
Madam Speaker, the 2 parties involved, Trinidad Petroleum Holdings and Nikwan Energy Trinidad Limited, are currently in discussions and are exploring all options to satisfy the contractual obligations under the agreements in question.
Member for Couva South.
Very much, Madam Speaker. Question 15 to the Minister of Housing and Urban Development.
Minister of Housing and Urban Development.
Thank you very much, Madam Speaker. Madam Speaker, the life of the Sugar Industry Labor Welfare Committee has not expired. Cabinet, at its meeting held on December 13, 2018, agreed that a team be appointed to formulate a plan of action for the dissolution of Silwick. Cabinet, in its meeting held on October 31, 2019, also agreed that the term of office of the team will be extended until May 11, 2020. This extension would allow the team to complete all required tasks. In the interim, the Silwick continues to function, Madam Speaker.
Supplemental member for Couva South.
Thank you, Madam Speaker. Minister, based on what you have just advised the House, could you inform this House if former ex-Caroni workers are owed any sums of money outstanding by Silwick as a result of payments they made to lands under the Silwick program?
Minister of Housing and Urban Development.
Madam Speaker, the team that's looking after the dissolution of Silwick are in fact dealing with all the issues pertinent to the former sugarcane workers and farmers. That with respect to preparation of deeds of covenants, preparation of deeds of lease, preparation of releases, memorandum of satisfaction, memorandum of discharge, consents for repairs, payments of debt owed to contractors by Silwick, and other matters, Madam Speaker.
Supplemental member for Couva South.
Yes, thank you, Madam Speaker. Minister, are you aware that Silwick owes approximately over $100 million to ex-Caroni workers who deposited monies as a result of paying for lands for the VSEP arrangement.
Minister of Housing and Urban Development.
Madam Speaker, I'm not aware of that. Madam Speaker.
Supplemental member for Couva South.
That is
What the Minister have said, Madam Speaker, I will urge the Minister to look into that.
Go on. Introduction of bills.
Statements by ministers, personal explanations, introductions of bills. On the supplemental order paper, the Administration of Justice Indictable Proceedings Amendment Number 3 Bill 2019. Motions relating to the business or sittings of the House and moved by a minister.
Leader of the House.
Just 1 second. Sorry, Madam Speaker. Having regard to the interim report of the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018, I beg to move that the committee be allowed an extension of 3 months in order to complete its work and submit a final report by March 31st, 2020.
Honorable members, the question is, be it resolved that the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018 be allowed an extension of 3 months in order to complete its work and submit a final report by March 31st, 2020. All in favor say aye. Aye. Any against? I think the ayes have it.
Public business, government business, bills, second reading.
The Attorney General.
Thank you, Madam Speaker. Madam Speaker, I've made inquiries of the leader of the bench opposite as to whether bills number 2 and number 1 could be debated at the same time, and I've received an indication that there is agreement to that. In those circumstances, may I be guided as to the procedure properly to debate both bills at the same time?
Attorney General. Attorney General, I think it should be circulated to you now.
Much obliged. Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Provide for the Regulatory Control of the Handling of Cannabis for Certain Purposes, the establishment of the Trinidad and Tobago Cannabis Licensing Authority, and connected matters be now read a second time. Madam Speaker, in accordance with Standing Order 51, I seek the leave of the House to debate together with this bill the Dangerous Drugs Amendment Bill 2019, which relates to the same subject.
Honorable members, is this the wish of the House?
Aye.
Okay, Attorney General, you may proceed. Leave is granted.
Madam Speaker, I beg to move that a bill entitled An Act to Provide for the Regulatory Control of the Handling of Cannabis for Certain Purposes, the establishment of the Trinidad and Tobago Cannabis Licensing Authority, and connected matters be now read a second time. Leave having been granted to debate that together with Bill number 2, which is the Dangerous Drugs Amendment Bill 2019. Madam Speaker. Madam Speaker, cannabis is the word that features in both bills today. And the history of cannabis is rooted in our country and, in fact, in our culture. Cannabis certainly can be traced to several ethnic, religious, and cultural traditions relevant to Trinidad and Tobago, coming from Asia, Africa, the Middle East, and indeed Europe. Prior to 1885, Madam Speaker, cannabis or ganja as it was known then, was completely legal for medical, recreational, and industrial use. In 1885, the Ganja Cultivation Licenses Ordinance was passed, imposing a license for cultivators of cannabis and tariff on their goods. The Ganja Ordinance of 1894 was passed to prohibit cultivation, sale, and keeping of ganja. This new law repealed the previous ordinance, and only licensed medical practitioners were allowed to keep and sell cannabis. All cannabis at this time was imported from the UK, Venezuela, and the British East Indies. The Ganja Ordinance 1899, set to repeal the 1894 law, ended up being amended to read, along with the 1894 ordinance, in those amendments, a separation between prepared ganja for medicine from unprepared or smoking ganja. Madam Speaker, it was in 1894, 1899 that the first bit of regulatory control for psychotropic substances, those substances which actually cause Opium Licensing Ordinance of 1879. And the psychotropic substances. That Ganja Ordinance of 1915 allowed the cultivation under the Director of Agriculture to make very specific regulations regarding importation, packaging, sealing, taxing, and sale of ganja, as well as rules for licensing and unlicensing, possession limits, etc. The Dangerous Drugs Ordinance of 1928 repealed that Ganja Ordinance of Opium Ordinance, and that happened as a result of the first Geneva Convention, Madam Speaker. Madam Speaker, the Narcotics Control Ordinance of 1961 repealed the Dangerous Drugs Ordinance of 1928, and that happened as a result of the birth of the Second Geneva Convention. Our present Dangerous Drugs Act, Madam Speaker, which is an act of Parliament coming into effect in 1994, that is Chapter 1125, 1991. That's an Act of Parliament number 38 of 1991. That has stood on the books of Trinidad and Tobago from 1991 straight forward. It was amended in 1994, 1995, 2000, 2000 again, and then in 2014. Madam Speaker, in our laws, people would be good in information to recount actually that our Customs Act, since Act number 22 of 1938, our Customs Act at Section 33 actually manages that no rebatement of claims can be made in respect of ganja that is imported. In other words then, this historical recount of the laws of Trinidad and Tobago proved the first submission made that ganja, marijuana, cannabis, whatever you wish to call it, has been a feature of our society for a very long time. Madam Speaker, the 1991 legislation actually is quite a robust piece of law, and in debating these two bills together, we seek in Bill number 2 to amend the Dangerous Drugs Act. In Bill number 1 to create a Cannabis Control Authority. Why do we seek to do it that way? We do so, Madam Speaker, to cleave the purposes before us. In the Bill number 2, we're treating with the concept of decriminalization of marijuana, which we now comprehensively describe as cannabis. We treat with where limits are to be imposed for possession. We treat with use in a private and public disaggregation. We carve out and ensure protection in respect of children. We carve out and ensure protection in respect of the use of the substance at work or in professional circumstances. We then ensure that a systemization is applied for when offenses are triggered for certain quantities under the prescribed limits. We treat with how possession in the bracket of 30 grams to 60 grams is to be managed. We introduce a fixed penalty system for that approach. We also, Madam Speaker, treat with, in that law, an improvement to the laws because they've not been essentially amended for a very long time. When last amended in 2014, the advances in the law were not taken on board. Some of the prescriptions for the offenses are not well organized. The offense limits are low. They still included an offensive formula in law, as per the case of Barry Francis, where a minimum sentence which ousted the court's consideration was used. So we took the opportunity to clean up the law as it has been structured by the result of the court speaking in the circumstances of what is constitutional or unconstitutional in the Dangerous Drugs Act. We then introduce, Madam Speaker, the concept of management of community service under the community services orders that can be done pursuant to legislation. And, Madam Speaker, we then deal with the amendment of the schedules to the Dangerous Drugs Act. That's Bill number 2. Bill number 1, which is the Cannabis Control Authority, we have cleaved out of the Dangerous Drugs Act because it would not have been proper to manage what is potentially an industry and certainly a medical and religious factor arrangement, medical in the terms of medical prescription for cannabis, and religious in terms of recognizing the Rastafarian faith as one of the faiths involved in religion. It would be inappropriate from a making law point of view to have parked those amendments in the Dangerous Drugs Act, hence Bill number 1. In Bill number 1, we encourage a licensing regime. There are several types of licenses which I will go into. Who can grant the licenses, under what circumstances, how the medicinal side of it works, how the religious side of it works. It is also married in to recent laws that we have passed, which treats with non-profit organizations and beneficial ownership and other structures. So let's get, before we get into the particulars of the bills, the two bills, the clause-by-clause arrangements, let's get to the data which drives why we are here. Because if we're looking to the constitutionality of law and its proportionality, we have to speak to what is reasonable in a society such as Trinidad and Tobago, certainly within the context of what the Constitution contemplates. These two bills do not require a special majority arrangement. They are simple majority bills. They do not require this arrangement because there is a licensing regime and there is a due process management inside of it. These bills are structured to allow for an address to the society of Trinidad and Tobago. I'll say that the laws have been born from a number of perspectives. We looked at the laws of Antigua and Barbuda. We looked at the laws of Barbados. We looked to the laws of Canada. We looked to St. Vincent and the Grenadines. We looked to the United Kingdom. We looked at Jamaica. We looked at the CARICOM Regional Commission on Marijuana in its publication of 2018. We then, Madam Speaker, had submissions come in from the Ministry of Labor and Small Enterprises Development. We had submissions from the Ministry of National Security and in particular also the Division of Forensic Sciences. We had the Minister of Health. We had the Minister of Social Development and Family Services. We had the Office of the Prime Minister. We had the Prisons Authority. We had the Ministry of Sport and Youth Affairs. We had the Trinidad and Tobago Police Service. We had the All Mansions of Rastafari position paper. We had the Islamic Perspective. We had the Islamic Ladies Social and Cultural Association. We had the second submission coming from the All Mansions Rastafari, which I in fact just got yesterday. And, Madam Speaker, of course, we had the Attorney General. We had the benefit, Madam Speaker, of an expert provide us with considerations, expert in the person of Mr. Marcus Ramkisoon, and we looked at the medicinal cannabis regulations coming out of the European context, in particular Holland and other jurisdictions, married across the several jurisdictions that I have managed. And I wish to thank profusely all of the persons that have lent contribution, coming from the University of the West Indies, coming from Mr. Ramkisoon, coming from Dr. Pottinger. Madam Speaker, it's now a matter of public record that we also held several consultations. In fact, Madam Speaker, we had consultations, 6 of them in total, with more than 1,000 persons in all. Those consultations were led by the Office of the Attorney General, my colleague, the very hard-working Minister Fitzgerald Hines, the member engaged in coordinating a large amount of this work together. We ran the campaign of public consultations, and we were ably assisted by some of the persons mentioned a while ago. Madam Speaker, may I just ask what time is full time for this debate?
2:59.
Much obliged, ma'am. Let's get to some of the statistical information. Let's get to what Trinidad and Tobago looks like. Madam Speaker, obviously, Trinidad and Tobago's law, the 1991 law, is driven by the factor coming from our international obligations. Our international obligations are in the conventions which we subscribe to. Those conventions, of course, are well known to us. We have the perspective of the psychotropic substances across, and I'll just get you for the record the correct sections of these international conventions. And then we'll dive into what the local law says in relation to it as against the statistics, Madam Speaker. So, Madam Speaker, let's look at the structures of the conventions. We have, for the record, the 1961 UN Single Convention on Narcotic Drugs. We have the 1971 UN Convention on Psychotropic Substances. We have the 1972 Protocol amending the Single Convention, and the 1988 UN Convention against illicit trafficking in narcotics, drugs, and psychotropic substances. But what I found interesting, Madam Speaker, in preparing the material and statistical arrangements for Trinidad and Tobago is that marijuana, cannabis as we call it in this legislation, has been a feature which is interrupting not only our society, but our criminal justice system. Madam Speaker, it's a fact that on average every year, the magistracy receives approximately 146,000 cases per year. In that 146,000 cases, Madam Speaker, we have approximately 8,500 of those cases coming specifically in relation to cannabis, possession, trafficking, cultivation, or gathering. And Madam Speaker, as a criminal management issue, the government is on record, our legislative agenda is well known. We have already demonstrated to the world that what we propose to do is to take the 146,000 cases in the magistracy, remove 104,000 out of them per year, which are motor vehicle and road traffic offenses. After we remove that 104,000 in or around the beginning of next year, 2020, we will also be moving, Madam Speaker, approximately 26,000 cases in the Magistrates Court, which are dealing with preliminary inquiries. We intend to abolish those, all things being equal, hopefully in the month of January 2020. If you take away 104,000 and 26,000 from the 146,000, and you now look to deal with the possession of marijuana or cannabis amounts, you will find that you are left with only approximately 8,000 cases per year in the magistracy. 43 magistrates in 12 courts go from dealing with 146,000 cases to dealing with 8,000 cases under a rules-based environment in a structure. Madam Speaker, when we looked at the data, we realize that in a 10-year period, we have seen a significant number of persons pass through the matrix. Madam Speaker, the 10-year period demonstrates that we have had roughly 85,000 cases in the period 2008 to 2018. 85,000 cases in the magistracy. That results, Madam Speaker, in the odd 7,500 to 8,000 cases per year. Of that 85,000 cases, Madam Speaker, we note that almost 85% of them, ranging between 85 to 87%, are just for simple possession of marijuana. Not trafficking. Trafficking is 1,000 kilograms of marijuana. Trafficking is if you are within 500 meters of a school as defined under the law, Section 5 of the Act. But when you look at simple possession, approximately 85% of those matters to 87% are for simple possession. That means trafficking is a much smaller number at 14% to 12%. Cultivation is in fact 0.6% and gathering 0.02% of the cases. What is interesting, however, Madam Speaker, is that when we look to the people who are put on remand, those are people who are arrested for possession, who are granted bail, who cannot access bail, are in pre-trial detention lawfully in remand conditions. That figure is alarming. Madam Speaker, I'm able to tell you that that figure across the prisons is a staggering number. If we look to the period 2014 to 2019 alone, we have had 4,694 people remanded for marijuana. 4,000, nearly 5,000 people remanded. We are on record as saying that that represents an average cost of anywhere between $15,000 per month to $25,000 per month per head, per person. And when you do the math across the period 2014 to 2019, that simple aggregation, we're looking at roughly billions of dollars spent on simple possession matters. What's more troubling is the risk factor exposure. When we look at the age bracketing, the vast majority of people are in the age bracket 18 to 35 or 35 to 50. Let me repeat that. The vast majority of remandees are from 18 to 35. And these remandees are being put into conditions alongside hardened, serious criminals. They are, when brought before the court, ultimately subjected to a fine because they have already had pretrial incarceration, and that fine is often a fraction of the money spent to actually keep them incarcerated, sometimes for even only 1 month. There's another troubling aspect to it. When we disaggregate the ethnic distribution, we see, for example, let's take the figure of 2014, where we had 973 people remanded. The age range of our African community in the bracket 18 to 35 was 352. We look to our Asian range, and we see none. We look to East Indians, we see 124. We look to mixed, we see 185. When we look to Hispanic, we see 3. When we look to the urban arrest phenomenon and the rural arrest phenomenon, we see that there's an equal distribution. It's not only an urban position. But Madam Speaker, these statistics, when compared against the disposition rates, are very troubling, because on average we are disposing of only roughly 24% of cases per year. Why? There are just too many cases inside the criminal justice system, hence our approach to remove motor vehicle and road traffic, remove preliminary inquiry, and remove cannabis-related offenses. Madam Speaker, the question right now is, where do we draw the line? Now, the 1991 Act, Madam Speaker, is actually a very robust piece of law, as I was saying a little while ago. It is robust in particular because it had a very useful phenomenon. The phenomenon is to be found in the fact that Section 4 of the current law says that the minister may, subject to regulations made under Section 57, issue licenses for import, export, diversion, sale, manufacture, production, distribution at a stated place of any dangerous drug. Issue licenses for the cultivation, gathering, or production at a stated place of opium, poppy, marijuana, or coca plant. Name the ports or places in the territory where the drug may be exported. Prescribe the manner in which the dangerous drug may be packed and marked for export. Authorize furnishing of dangerous drugs to master of a ship. Prescribe records. So we have in Section 4 the formula to treat with the licensing regime for all dangerous drugs. Coca plant, obviously, cocaine, derivatives used in anesthesia, in medicinal application, opium, again in derivatives that way. But cannabis, marijuana, has always been capable of being treated with by any government since 1991. It was previously treated with since 1838. When we look to this, Madam Speaker, we note that possession and trafficking of dangerous drugs is the crux of where we are. Basically, Madam Speaker, in Section 5 of the Act, possession of dangerous drugs amounts to serious interruptions of your liberty and certainly fines that may be put upon you. So let's see what the law that we propose in Bill number 2 is, and I prefer Bill number 2 first in terms of setting the context, and then go to Bill number 1. The first thing we do is we remove these ad hoc references to marijuana. Marijuana is defined in the first schedule of the Dangerous Drugs Act. It's in fact at number 3 of the first schedule. The first schedule is where we set out the list of dangerous drugs. The list of dangerous drugs in the first schedule includes at paragraph 3 a definition which allows for basically, and I'll actually read it into the record, it allows for the position of scientific reference to what constitutes marijuana. That is, and I'm just looking for the correct page, Madam Speaker. I'll get to it in a second. That, Madam Speaker, is certainly not a definition which finds itself in the body of the Act. That definition, Madam Speaker, is where we propose that we have an amendment. The first schedule treats with it in item number 3. Marijuana is defined effectively in the first schedule number 3 as cannabis, cannabis sativa, cannabis sativa L, their preparations, derivatives, and similar synthetic preparations as, for example, cannabis resin, cannabis marijuana, cannabidiol, and it goes into the chemical distributions of that. That, Madam Speaker, left confusion in the architecture of the law itself. We propose in clause 4 of the bill, this is bill number 2, to amend the definition section to include a definition for cannabis. We give a standard definition that is used effectively around the world right now. And Madam Speaker, what we do by treating with that is that we then also add in the definitions that we're going to use a little bit later. We've put in what a public place is. A public place is any indoor or outdoor area, whether privately or publicly owned, to which the public has access by right or by invitation, express or implied, whether by payment of money or not. We define smoking. We put smoking in to include the various iterations, including now e-cigarettes. We also, Madam Speaker, then go to manage the use of the amendment section in the definition section. In section 4 of the Act, which we do by clause 5 of the bill, we treat to call cannabis by its proper reference. We remove the references to marijuana and replace it with cannabis. It's section 5 that we jump to when we're looking to the law and the offenses. Clause 6 of the bill amends section 5 of the Act. And here in the first part in clause 6A, what we're doing is we are taking a note of the decision in Barry Francis. We're removing the minimum penalty prescription in law, which was 25 years, and we have improved the sentence upwards from $25,000 on summary conviction to $250,000. There's been a movement in that position. I remind that under Section 68 of the Interpretation Act, any statement of a fine or a jail term is a maximum sentence. The law is very clear. You can get anything from 0, i.e. nothing at all being applied to you, up to the maximum sentence. This does not mean if you trip this, you have to pay $250,000, Madam Speaker. It means that you can get anywhere from 0 upwards. Madam Speaker, we treat with the improvement in the indictable route. We now, because it's all dangerous drugs, cocaine, etc., we treat with $1 million as the maximum amount, or 15 years. Madam Speaker, what we do in clause 6B is that we now add in where you will not be guilty of an offense. And specifically, we are now adding in that where a person has in his possession not more than 30 grams of cannabis or 5 grams of cannabis resin, that effectively you will not be committing an offense. What is 30 grams? Put quite simply, 10 grams is a pack of 20 cigarettes. 30 grams is 60 cigarettes. 3 packets of Du Maurier or whatever cigarettes. I'm not a smoker, but I can tell you, Madam Speaker, I've seen the quantity. Imagine 3 large packets of cigarettes. That's what 30 grams equals to. 30 grams allows you the ability to have no offense for possession. We, of course, take with it in the resin context because you can desiccate the substance into a more potent version, and that is resin, and we go with 5 grams of resin. Why have we taken that amount of 30 grams? We've taken that amount on the back of statistical information coming from the Forensics Institute. The Forensics Institute tells us, Madam Speaker, that we are looking at the structures against what they are called upon to analyze. We scrub that against what the court does. We realize that anywhere under 60 grams, you're effectively under the sentencing guidelines getting only a monetary sum from the court. You're putting thousands of people in remand conditions, delaying their trial, having them come out to pay a fine, spending $25,000 a month to keep them inside of there and exposing them to the tragedy of incarceration. When you look to the statistical analysis coming from the forensics decision, Madam Speaker, the forensics data says basically that if you decriminalize, you cause them not to have to investigate under 60 grams, and that I'll come to in a short second. Under 60 grams, you're going to be taking away approximately 75 to 85% of their caseload. Let me repeat that. By removing these limits, causing the exceptions under 30 grams and under 60 grams, you are removing the large chunk of the forensics work in this country, leaving them capable to actually look at more serious matters, for instance, rape analysis in the rape kits, etc. But Madam Speaker, listen to this. The forensics data is quite interesting. Let's take the period 2009 to 2016. I asked for and got disaggregated information of dangerous drugs, cocaine and marijuana. For cocaine in 2009, both of them combined, narcotics received 1,380 cases at forensics. Marijuana, cannabis, was 1,064 of those cases. Cocaine was 316. In other words then, 77% cannabis, 23% cocaine. By liberating the analysis of cannabis, you're allowing forensics to push through the dangerous drug of cocaine, of opium, or any other substance. I'd stick a pin and say, of course, members are made aware or reminded that we amended the schedules to the Dangerous Drugs Act via the Minister of National Security sign-off on orders. We amended the psychotropic substances in Schedule 1 and Schedule 2. We have included ketamines and amphetamines and LSD in its lysergic acid form. It's a lysergic amide, if I'm not mistaken. I can't remember the chemical name. LSD. We've added those in now to manage the prevalence of ecstasy and other drugs. They are now dangerous drugs listed, and we prefer to have forensics focus on that kind of material instead. The percentage figures 2010, 11, straight up to 16 are roughly the same. It's a distribution of 80% cannabis and roughly 20% other drugs. We believe, Madam Speaker, that in treating with the decriminalization of substances under 60 grams, that we can get there. Now, I've heard it said, I saw the All Mansions Rastafarian group write in asking for 2 kilograms of cannabis to be per person to be the lawful amount. Madam Speaker, nowhere in any jurisdiction have we found any amount beyond 56 grams. And because there is a psychotropic substance effect, we have struck the CARICOM harmonized perspective. In fact, we would be 4 grams higher than everybody else at 60 grams. Jamaica's at 56. Barbados is moving up to perhaps 60. I've spoken with the AG of Barbados, and the other jurisdictions are managing it. In the CARICOM CSME context, we're looking to harmonize the output, and therefore we have sought a harmony in the CARICOM perspective. Madam Speaker, when we look to the convictions, effectively in Clause 6 of the bill, we are saying that if you are caught with more than 60 grams, more than 30 grams, but not more than 60 grams, we are going, and then we deal with between 5 grams and 10 grams of resin. We're going to subject people under Clause 7 to a fixed penalty route system where your first port of call will be an invitation to pay a $2,000 fine. By a fixed penalty notice under the Summary Courts Act, a ticket will be issued to you. You have the option to challenge it. If you challenge it in court under the fixed penalty route and the Summary Courts Act, the fixed penalty notice will be deemed to be a summons. You can appear at court. You can defend yourself. Forensics will kick in at that point, have analysis, and treat with it. So if you want to object it, you have the opportunity. If you want to pay, there's a complete exculpation that will be treated with as fixed penalty notices are. It's not a conviction. We then ask in this bill, Madam Speaker, in the new clause 2B, this is in clause 6 of the bill, we say if you don't pay the fixed penalty notice or you are found guilty of an offense, because you went to court, you challenged it, it was found, it's at that point that you'll be subjected to the maximum penalty in 2A of $50,000. Remember, you can get anywhere from a reprimand and discharge to $50,000. But in 2B, we say that the court should consider the alternative of a community service order, and we prescribe 30 hours of community service there. Alternate treatment, it's synonymous with the drug treatment regime that we have done for children in the Family and Children Division regime. Madam Speaker, we specifically say that the law will not apply to people who are in possession of 4, the bill says male growing plants. We will strike off male. This came from the recommendation of the Forensics Division. The fact is that the plant is grown in both male and female species. It's required for cross-pollination and different iterant variations. The members of the public came back to us and pointed that out. We agree wholeheartedly with the submission. It'll just be for plants. It can be male or female, whichever one you choose, but for possession of 4 growing plants is what you're allowed to have under this law. Madam Speaker, we harmonize in clauses 6F, G, H, I, the improvement of the sums and penalties. In 6J, Madam Speaker, is where we include the possession of a dangerous drug for the first time, harmonizing the orders. We're dealing with ecstasy, which is methylene dioxymethamphetamines. We've added that into the first and second schedule. We've dealt with lysergic acid, which is diethyl amide, and we deal with ketamine. So we're putting those in the context of trafficking and possession issues because these are now very dangerous in our society. We specifically in clause 7 say if you smoke cannabis in a public place, you're committing an offense. Why? Because you're provided with the opportunity to do it in private. We're saying that we're putting an obligation upon an owner or a person with responsibility for a place to treat with the control of the environment. There's no offense for that, but we're putting a positive obligation to allow you the privilege of telling people to leave your premises. Madam Speaker, we in clause 7, that's where we add the fixed penalty regime in accordance with the law, that we also allow the introduction of the payment of your penalty and the filing of your notices. You don't necessarily need to go to the court in the district. You can take advantage of the Court Pay Electronic Payments Into and Out of Court Act 2018, which, as you know, we passed and is in operation. That's Act number 14 of 2018. Madam Speaker, we then, of course, get down to the offenses. We say that you should not be under the influence of cannabis and do anything which constitutes negligence, professional malpractice, or professional misconduct. You should not have cannabis or cannabis resin on a school bus, school premises. I'm going to ask for an amendment to use the same definition that we did in section 5.8 by cross-reference. You should not navigate or be in control of any motor vehicle, aircraft, ship, etc. We then treat with a person who was charged under the law previously. And what we're doing, Madam Speaker, in the new clause 5D, in the new section 5D as clause 7 proposes, is we're saying, look, it is commonsensical and axiomatic that after you pass this law, anybody who has had a conviction should have it expunged. That expunging should happen under the provisions of the Police Service Act, section 50 in particular, 50K. We also treat with it to allow you to go to the court and be discharged. We also allow you to apply for a pardon. Now, we had to do that pardon on a case-by-case basis because the Privy Council in the case of Lendor has said you can't do it en masse. So people will be compelled to apply to the Mercy Committee, which exists under Section 87 of the Constitution, to make a recommendation for the discharge. Those will be, in fact, treated with alacrity. Both the Minister of National Security and I sit on that committee. We're familiar with its pace and function. Madam Speaker, let's jump to the Cannabis Control Bill. The Cannabis Control Bill, Madam Speaker, is an interesting law. I've given you the rationale for segregating it from the position of the Dangerous Drugs Act. The Cannabis Control Bill is the law which we set up for regulatory control of the handling of cannabis and also the establishment of the Cannabis Licensing Authority and all matters connected with that. The bill, Madam Speaker, is 69 clauses long. But it is not anything that occupies our attention beyond what we're accustomed to. We're setting up a statutory authority. We are appointing members. We're establishing the board. We're identifying functions. We're identifying powers. We're ensuring an independence of appointment. We are ensuring what the quorum looks like. We then go in part 2 to understand what their financial provisions will involve. In part 4, it's where we get to the licensing provisions. Part 5, here's where we segue into the medicinal cannabis. Part 6, cannabis for religious purposes. Part 7, the register. Part 8, inspections. And Part 9, miscellaneous. Now, we premise inspections in Part 9 on the back of a license which says if you want to apply for a license, you are authorizing the police to come or the inspectors to come in certain circumstances. If you don't want a license, that's your opportunity not to have the police involved. If you were to compel the obligation of the police into the law, you would require a 3/5 majority, and we have not gone that route. We're asking for warranting in the standard format, due process in the standard format, conditionalities of licenses in the standard format. And that's why this law does not require a special majority. Madam Speaker, let's get to the bill itself. In those 69 clauses, Madam Speaker, we specifically, the heart and soul of it is the ability to have the issuance of licenses. We allow for the issuance of 8 types of licenses: cultivator license, research and development license, a laboratory license, a processor license, a retail distributor license, an import license, an export license, and a transport license. We allow for 5 of those types of licenses to be issued to a religious organization. The religious organizations must, in Constitution, be non-profit organizations, and I should say all religious organizations are going to head that way, because that's what the non-profit organization law contemplates. Those licenses which are relevant to religious organizations are a cultivation religious license, a dispensary religious license, an import religious license, an export religious license, and a transport religious license. Madam Speaker, when we get to the heart and soul of the authority itself, and that's in Part 2 in sections 4 to 18, we of course, Madam Speaker, make sure that we provide for conflicts of interest, disclosures of interest, prohibitions against members of the licensing committee being involved in the industry via their friends, family, associates, etc. Madam Speaker, the authority's powers are set out, the establishment in Clause 4, in Clause 5, the functions effectively advising the minister in certain circumstances, and then of course their powers in relation to the licenses, to grant, amend, suspend, revoke, etc. We set out what the performance of their functions will involve, and in the board I ask you to note that we're asking for members to be disciplined in law, management, finance, accounting, medicine, scientific research, agriculture, law enforcement, education, or drug rehabilitation. And Madam Speaker, we're saying the President shall appoint one of the members to be the chair. The members shall be appointed for such term of 3 years, eligible for reappointment. The President will determine remuneration. Where vacancy arises, that you can have temporary appointments. The chairman or deputy chairman may resign in the function and fashion. How the President may revoke the appointments in circumstances set out in Clause 8, the publication of the persons, the exculpation of liability for things done in bona fide circumstances without recklessness or bad faith in Clause 10, how the meetings of the boards would happen in Clause 11, the quorum for decisions being made, the disclosures of interest in Clause 14 in particular, where you must make sure that you are not engaged or employed in the handling of cannabis or have actual or contingent pecuniary interest. And we define that right along the horizontal and vertical relationships that are common in that circumstance. We deal with the CEO's appointment in Clause 15, the staff and experts in Clause 16, how they may be added to, where the delegation of functions happen in Clause 17, Madam Speaker. The financial provisions are effectively stable. They are nothing that we are not accustomed to. In the circumstances here, we're saying that the fund that they will use will be comprised of the appropriations from Parliament, in the fees, sums borrowed, sums received, such other sums, and how they will deal with these funds, the application of funds in Clause 21, down to authorized investment. There's a general philosophy permitted in this law to allow for support and functionality for drug rehabilitation, taking people away from it, education as to the risks of the psychotropic nature of these matters. We deal with IFRS standards, accounts, auditing of accounts, standard section 116 of the Constitution application, Auditor General. We deal, Madam Speaker, with how they may invest money. The licensing provisions beginning at clause 30 in the part 4 of the bill, this is where, Madam Speaker, we allow for the issuance of the licenses that I've said, but the conditionalities are that you must issue a license to a person who is 18 years or older, must be a citizen of Trinidad and Tobago, or a permanent resident of Trinidad and Tobago, or a citizen of a CARICOM member state other than Trinidad and Tobago, or be a company or firm or cooperative society. Here is where we establish the local content. In the local content, Madam Speaker, you see in subclause 4 that at least 30% of the company or firm or cooperative society must be owned by locals. Why? The experience in the industry has been that the large players from North America and elsewhere come into the market and effectively cannibalize the market, pushing out the people who are the very advocates for the cultivation and proper exploitation, I don't mean that in a bad sense, of cannabis for all of the right reasons, be they medicinal and other factors as well. Madam Speaker, we then go in the information and licensing application regime, your rights of appeal for suspension, for revocation, your rights of management and due process for that position, how refusals are dealt with, how transferability is dealt with in clause 36, how renewal of licenses happen. It's clause 39 that we treat with the enforcement actions, notices of non-compliance, suspension, etc., Madam Speaker, the effect of suspension on aspects. Clause 5 treats with the medicinal cannabis, and in that we can actually treat with how we deal with prescribable versus non-prescribable cannabis, because it's a quantifiable amount of THC that is really the element that is on test. We contemplate dose limitations, the keeping of records, the strict maintenance of these substances away from children, how you treat with it in the circumstance of persons who act on behalf of children, the risk and obligations to doctors and other professionals, vets, dentists, etc. And it's clause part 6, which treats with cannabis for religious purposes. The religious purposes contemplate sacramental and dispensary obligations, how it is dispensed with, what the controls are, what the liabilities look like, how children are to be specced with. Registration happens under Part 7, inspections under Part 8. The authority has an inspection program. The inspection may take action. The inspector shall have 24 hours, etc., filing of a report. Warrants are provided for in section clause 65, Madam Speaker, so that we are keeping to the due process and not interrupting fundamental rights. The miscellaneous provisions of civil penalties and general penalties apply, and of course appeals. If you're aggrieved by decisions, you apply to the Environmental Commission, and the Environmental Commission shall make such order as you think fit. It is from there that you have further reliefs as well. Madam Speaker, as I have 1 minute left, I'll say this has involved a massive amount of work beginning in the year 2016 go forward. Trinidad and Tobago is not a theocracy, it is a democracy. Trinidad and Tobago will never have a unanimity of purpose. There are some who say legalize, there's some who say decriminalize, there's some who say do nothing at all, enhance the functions and penalties. This is not an easy balance to be had, but common sense tells us that it's by far past the time to make sure that the criminal justice system and the people most at risk are not exposed to the inevitability of just being processed through after a whole lot of time, exposed to danger for a mere fine. It is by far time that we treat with that. I am pleased to have joined in the authorship of this work. I commend the Honorable Prime Minister for having the courage to treat with this issue. It took a little bit of convincing, but he is a man that is very analytical in his approach, and I take his guidance seriously at all points in time. I welcome the debate today, Madam Speaker, and I beg to move.
Honorable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Provide for the Regulatory Control of the Handling of Cannabis for Certain Purposes, the establishment of the Trinidad and Tobago Cannabis Licensing Authority and connected matters be now read a second time. Honorable members, you are reminded that leave has been granted for bills number 1 and 2 to be debated together. Member for Barataria.
Madam Speaker, on the outset, as I start this presentation, thank you for recognizing me. I would like to indicate to you, Madam Speaker, that these bills are not as simple as they are made out to be. The Attorney General has done his discourse, and the position on our side, the Honorable Leader of the Opposition has indicated that she is in favor of, that the leader is in favor of marijuana for medical uses. And these bills should be subjected to a joint select committee for further assessment and continuation to have a better set of bills coming to the Parliament. That's the outset. I would like to make that is our recommendation, that both bills be sent to the joint select committee of both houses. Madam Speaker, the Honorable Attorney General spent most of his discussions indicating the positivity of decriminalization just for clearing the courthouse. Most of his presentation was done on that note, that we will have 104,000 cases plus 56 cases, 85 cases, 85,000 cases, and then went down to say about different percentages. Madam Speaker, if that was the objective of this bill, then truly he could have come with just a simple amendment without the other parts of the dangerous drugs bill. And a simple amendment saying, I've come here to clear the courthouses and to work on the system where we can, the disadvantaged people in the courthouse will be at least given a chance in life. Madam Speaker, about 3 years ago, I called for this to happen, for decriminalization, Madam Speaker. Not legalization, but decriminalization. And I'm very glad to see that the Honorable Prime Minister has taken it on board, because initially he was not for it based on his utterances. Certain utterances. Now,
Members, I'm warning everybody with respect to Standing Order 53. Member for Barataria.
thank you, Madam Speaker. Madam Speaker, the excise taxes for alcohol in this country is predicated on the percentage of ethanol in the alcohol. And we could lump everything under alcohol, but when we tax it, it's based upon the percentage of ethanol in the alcohol. I make that point, Madam Speaker, because I want to say, at the outset of this bill, as we start reading the Dangerous Drugs Bill, first part, the bill seeks to decriminalize the possession of not more than 30 grams of cannabis. As the Attorney General indicated in the previous act, the parent act, marijuana comes from, and it is defined for cannabis sativa, cannabis indicus. The reason behind that, Madam Speaker, those two genuses of the plant, cannabis plant, has the tetrahydrocannabinol delta 9 of exactly 25% and over. That is the psychotropic part of the plant. Now, we have to ask ourselves, is cannabis a dangerous drug, or is THC the dangerous drug? What is the definition? Which one is the dangerous drug? Is it the plant cannabis, or is it the substance produced by the plant, which is the THC? And the ones that get you high, the ones that get you, as you say, in different frames of mind, at 25% and above from the female plant of the marijuana plant of cannabis sativa and cannabis indicus, that is the one that produces the higher level of THC that gives you the recreational high. However, in very low doses, Madam Speaker, 1%, which could be found in the cannabis oil, less than 1% to 0.3%, those are the same drug, THC, which creates a mood, as I say, a mood-altering feeling for depressed people. as well as those people who are vomiting and going through different medical problems as spasmodic contractions, neurological disorders, and different mood swings and sleep problems. However, Madam Speaker, the reason I make the point of the percentage of the THC, when you use the word cannabis, you are lumping into the whole system hemp. And hemp is not a compound that has a large amount of THC. It has 0.3% or less. But hemp is used, Madam Speaker, for a lot of other things. Textiles, clothing, diapers, handbags, denim, shoes, fine fabrics, industrial textiles, rope, canvas, and we go on printing of paper, foods, hemp seed oil, hemp protein powder. It goes to oil paints, varnishes, body care, soaps for skin diseases. And when you lump the word cannabis, you are lumping together hemp, you're lumping together CBD oil, which is used for medical purposes. You're lumping together the THC part of it, which is used for recreational marijuana. So all the Attorney General really came to this House today to speak about was that the dangerous drugs bill is going to be used to free people from the jails, remand yard, decrease the court load, and then we could say that we did something. Madam Speaker, this bill goes deeper than that. It's much deeper than that. And it speaks about not only having dangerous drugs, but that is the first part about the THC part of it, Madam Speaker, and the medical part of it. It says nothing about, in fact, according to the dangerous drugs bill, if you have the CBD and oils, and it's more than, let's say, about, I think, 5 grams or whatever it is, in your possession, and you have 1 gram in your possession, the CBD oil, and you have 5 people in a vehicle, which is a taxi, will those people be taken down as a total of having it in a public place? Now, Jamaica, in the Jamaican legislation, they make a distinction between the Delta-9 tetrahydrocannabinol in the marijuana plant, as compared to what we are doing here, lumping it in one plant. And the Jamaican model speaks also, Madam Speaker, about the same things that we are trying to do, change the system where the remand yard underprivileged person can be freed. Now, certain other parts of this legislation in, let's say, the Dangerous Drugs Act, Madam Speaker, you have, as I said, the real issue is it marijuana or is it THC? But in the smoking in a public place, Madam Speaker, what is a public place? A public place, Madam Speaker, means an indoor-outdoor area, whether privately or publicly owned, to which the public has an access by right or by invitation, expressed or implied, whether by payment or with money or not. If you smoke in a public place, you could be, Madam Speaker, fined in 5(8), Section 7. A person who smokes or uses cannabis or cannabis resin in a public place commits an offense and is liable on summary conviction to a fine of $250,000 and to imprisonment for 5 years. So if I'm smoking hemp, Madam Speaker, if I'm smoking hemp in a public place, and a police says that is you're smoking cannabis, which is hemp is a cannabis plant without much THC, I could be fined $250,000 and to imprisonment for 5 years. That is what it is. This is what this bill is saying. It's not saying if you are smoking a cannabis plant with a THC of above so much or how much grams of it. No, it specifically says cannabis in a public place. Now, a public place, according to this definition, Madam Speaker, is broad. It is so broad, Madam Speaker, that anywhere and anything could be a public place. And when we say that, Madam Speaker, you're looking at, you can't smoke it anywhere. Because wherever the public has access to is considered public space. In Jamaica, Madam Speaker, in Jamaica model, the Jamaica model speaks about a public place, but they define it. A public place, for the purpose of these smoking rules, a public place includes a workplace and any place which is not for use or accessible to, which is for use or accessible to the public, such as sidewalks, bus stops, restaurants, offices, education institutions, pharmacies, hospitals, areas used by children, supermarkets, and parks. However, smoking of ganja in privately occupied residences and not used for commercial purposes is not an offense, but is governed by the same ganja rules. Madam Speaker, if, however, you smoke in a public place in Jamaica, the police, a person who is found in possession of 2 ounces or less, and who is, well, no. A police may issue a ticket to a person in possession of 2 ounces of or less of ganja, similar to a traffic ticket, and the person has 30 days to pay. I'm looking for the part, Madam Speaker. I can't find it. I'll get it in a while. Madam Speaker, so looking at this piece of legislation, where you have the difference between hemp and the difference between marijuana, not defined by this legislation, you could run the risk of a police officer taking you down and you having to pay $250,000 versus, and also 5 years imprisonment, Madam Speaker. Now, cannabis resin, according to this definition, means the separate resin, whether crude or purified, obtained from any plant of the genus Cannabis. Any plant means it could be coming from cannabis, the hemp, which is a cannabis plant. It could be coming from Cannabis indicis or Cannabis sativa. There's also Cannabis rudalis, which has a very low content of THC. Now, using the cannabis resin of 5 grams as the cutoff point, Madam Speaker, it means to say that if you have CBD oil with a low THC content for medical uses, and it's more than 5 grams, let's say 5.5 grams, you run the risk of being charged as somebody in possession for the same $250,000 and 5 years in prison. And it goes on, Madam Speaker, that more than 5 grams or not more than 10 grams of cannabis resin. This is Section 2A. Subject to Section 5B2, a person who has in his possession more than 30 grams or not more than 60 grams of cannabis, or more than 5 grams but not more than 10 grams, commits an offense and is liable on summary conviction to a fine of $50,000. So, Madam Speaker, looking at these 4 parts and the change of the amendments, you have to ask yourself, if this goes through today, Madam Speaker, and it passes because of a simple majority, what next? We are going to be subject to this level of ambiguity in this legislation. And a joint select committee, Madam Speaker, could flesh it out, come up with better ideas, looking at the percentage of THC, the percentage of marijuana, the 25%, and because marijuana, you make CBD oil from marijuana, but the content of the THC and the CBD oil used for medicinal purposes, for skin creams, etc., is less than 1%. However, the recreational marijuana, which from the flowers and the seeds and the poppy, you get a THC level of 25% and above. Sure.
Are you proposing, therefore, that you to analyze which bracket that you're in, THC? Who's going to do the analysis for that? Are we going to send everything to forensics, let them figure out the THC? Because the plant substance, the plant-like substance, would have to be analyzed as its THC content. So effectively, what you're proposing is take all cannabis in Trinidad and Tobago, figure out what the percentage of THC is, and then treat with it?
No, what I'm saying is that, what I'm trying to say is that if you have hemp, somebody who has hemp and hemp oil and hemp seeds, that THC level is not going to be high compared to a sativa. Yes. It looks differently. They're different. No. And you could also, okay, THC can be analyzed by magnetic resonance systems. You could analyze the quantum of it. So what I'm saying to you, Honorable AG, what I'm saying, I understand what you're doing, but the thing about it, you've gone further than what we want to go. And Madam Speaker, through you, if you want to really and truly give the public a chance at the legislation, rather than block it to basically clear the courts, you have to define this thing properly. In the previous bill that they have changed, cannabis was defined as sativa, and I think indices are one of those. They actually defined it. In the Jamaican bill, they defined it. Now, the Honorable Attorney General has just asked a question, but will leave with another question. Because if a police officer in section, where police, this is section 2, section 7, 5.8, I think 5B2, where a police officer has reason to believe that a person is committing or has committed an offense under section 5.2a, he shall issue to the person a fixed penalty notice, charging him with the commission of such offense and requiring him to either pay the fixed penalty within the time specified or the fixed penalty notice. Madam Speaker, somebody has committed something means it's a past tense. It means to say that that person has done the act already. How can a police then determine exactly what compound was being smoked or inhaled, etc.? You have to test it. You have to test it. You have to do a blood analysis of THC. You cannot find somebody for a fixed penalty without doing a blood analysis. What, if you have, Madam Speaker, if you smoke or inhale THC, the concentration in your blood goes up rapidly and drops rapidly. If you eat cookies or you eat it, or the plant or whatever it may be, the concentration slowly goes up in the 2 to 5 hours and slowly dissipates. So if somebody smokes or inhales something, and you see him smoking or inhaling, how do you arrest him? By smell? You say it smells like it looks like it, so it is it? Then alcohol could be done the same way. It smells like alcohol, it looks like alcohol, so you have been drinking alcohol, forget the fertilizer, are taking you down. What I'm saying, Madam Speaker, the bill needs more work. Of course, the Attorney General wants to get ahead with clearing the court system. We have no problem with that. We agree to that. But the extension of the bill and the other extensions of the dangerous drug bill and the dangerous drugs, etc., and the penalties and what you're going to do with it, and the lack of diagnosis, the lack of investigation, and you can't have that in the bill if you want to have a committed position. The Attorney General's committed position is clear the courts. That's his committed position. This is just, the other just added numbers to it, to clearing the courts. And looking at days and times. Now, Madam Speaker, I looked up the literature to find out how do other countries determine when somebody has been smoking or inhaling under the influence of the THC. They've come to research papers where the THC levels in the blood is about 3 nanograms per mil. Sometimes is a measurable quantity of THC, Madam Speaker. Sometimes there's what they call the field test, where they have you walk up and down a straight line and whatever maybe and see if you're under the influence of a psychotropic substance. They might not know what a psychotropic substance may be, but if you're driving a vehicle and you cannot do a proper field test, it means to say that you have been on, there's something wrong. They can take you to the station and take a blood test and check your THC levels or your blood levels for alcohol. Nothing in this bill says that. It says if you have somebody driving an automobile, where is it? Driving an automobile, or it talks a lot about fixed penalty. A person who is charged. A person under the influence of cannabis does anything which constitutes, Madam Speaker, this is section 5C, which constitutes negligence, professional malpractice, or professional misconduct, and it goes B, well, has cannabis on a school bus, etc. You could determine that. Or C, operates, navigates, or is in actual physical control of any motor vehicle, aircraft, or ship while under the influence of cannabis, commits an offense and is liable to, on summary conviction, to a fine of $250,000 and to imprisonment for 5 years. You are now telling me that you cannot take the THC levels, you cannot tell me what were the levels of THC in that person who commits negligence, professional malpractice, professional misconduct. What is the peak blood levels? How are you going to determine that person is under the influence of cannabis? But yet you're saying here, with a penalty of $250,000 and imprisonment for 5 years if you're under the influence of cannabis. No, it's not saying if you're under the influence of THC, you know. It's saying if you're under the influence of cannabis. What part of cannabis are you under the influence of, Madam Speaker? Are you under the influence of what percentage of cannabis, THC? Are you taking CBD oil? That is cannabis. Are you taking hemp? That is cannabis. No, are you taking hemp seed oil? That is cannabis. Hemp seed oil has less than 1.1% of THC. No effect on your psychotropic levels. CBD oil, medical CBD oil used for whatever medical ailment, less than 1% of THC, but they're all cannabis related. They're all cannabis. So the definition of cannabis, Madam Speaker, begs the question, are you going to subject people in this country to fines of $250,000 and to imprisonment for 5 years? Based on what? Based on what blood level? There's no blood breathalyzer because the bioavailability and the physiology of THC, Madam Speaker, you orally take it or you inhale it or smoke it, it goes through the liver. It's broken down in the liver and is excreted in the feces. Some comes out in the lung. Not much comes out in the breath. So you can't use a breathalyzer. You may get some in your saliva, but it's in the bloodstream if you catch it at the right time. If you catch it, it depends on how it's inhaled or smoked. If you catch it at the right time, you could get the right concentration. But, Madam Speaker, are you going to continue to subject the people of Trinidad and Tobago to these draconian measures based on a supposition that they were taking cannabis? Are you doing that? No, you could really roll it through, but because a simple majority. But in these proclamation, and I would love to know, you are decriminalizing something, Madam Speaker, and we have no objections, Madam Speaker, we have no objections for this bill, but it's how it's being done. And it needs further work, Madam Speaker. We can't just come and say it's a simple majority with draconian penalties and say, well, we'll pass it anyway because it's simple majority. If the penalties were like Jamaica, where if you're found smoking in a public place, you are fined like a traffic ticket, Madam Speaker, $500 Jamaican dollars. Yeah, $500 Jamaican dollars. If you're fined on a sidewalk, etc., $500 Jamaican dollars, traffic ticket. However, if you have things that are above 2 ounces, then that is another kettle of fish. Understand we are doing the same thing here. But when you look at it, Madam Speaker, in Jamaica they talk about hemp. In Jamaica they said hemp is defined by the DDA, Department of Drug Administration, as a ganja plant having a THC content of less than 1%. This is defined. Hemp is used to make a wide variety of products from cloth, paper, and rope to medicines, beverage, and cosmetics. hemp is excluded from the provisions in the DDA that apply to ganja. It's here in the Jamaican legislation. However, the cultivation, processing, sale, import, export, and other handle of hemp may be regulated by a licensed regime administered by the Cannabis Licensing Authority. So you see, Madam Speaker, they define hemp as something with a THC level of less than 1%. In our legislation, Madam Speaker, it talks about a permit for visitors into Trinidad and Tobago. The Jamaican model says if it has been recommended by a licensed medical practitioner in the country where they live, and they can sign a voluntary declaration to confirm this, the permit is issued by the Jamaican Ministry of Health on a voluntary declaration, and a fee is payable. Madam Speaker, we really need to dissect the two bills, Madam Speaker, in a joint select committee. It cannot continue just because it's a simple majority. Smoking, Madam Speaker, smoking of ganja in Jamaica. Smoking of ganja in a public place or within 5 meters of a public place is prohibited in a matter similar to cigarettes. Tobacco. A person who smokes in a public cannot be arrested or detained. However, the police may issue a ticket to that person who will have 30 days to pay $500 Jamaican at any tax office. That's Jamaica. It's here. I agree, but what I'm saying, we're still people, Minister. And we need, you have Jamaican people, you have Trinidad people, you have Jamaican Rasta, you have Trinidad Rasta, and at the end of the day, you don't want to hold a Rasta, your brother, in a public place and charge him $50,000. No. I was going to.
Attorney General.
Satisfied if the public place smoking was treated with by the same fixed penalty notice we have here?
It would make sense.
Great.
But as I say, a lot more things, Madam Speaker, should be fleshed out in a GSE. I mean, we can have a short GSE. GSE doesn't, the Honorable AG is on record in today's papers, he wants to pass it by Christmas. At least have a GSE for a week. Have a GSE for a week. Madam Speaker, this is, you see, smoking in a public place, we agree, Madam Speaker, that they need to have penalties around school children, school buses, school areas. But what happens, Madam Speaker, if you're in your private residence and your child is next to you and you smoke in your ganja, is that correct? You understand what I'm saying? But in a private residence in Trinidad and Tobago, you can smoke. But it doesn't detain not next to a child of a certain age, 18 years and below. It doesn't say that. This needs to be said here, Madam Speaker. Madam Speaker, we also have no objections of the fixed penalty. A fixed penalty for anything between 30 grams and 60 grams, which is 1 ounce, a little above 1 ounce and 2 ounces. You could run the risk of a fixed penalty, but that is if the police officer catches you with it, gets you with it. And I think the fixed penalty is $2,000, and it can be paid according to what the Attorney General said, which is not a bad idea, Madam Speaker, because we are under the impression that those quantum of marijuana should not be subjected to draconian penalty, because they're not for trafficking, or they're basic possession, but not overt trafficking. And all these nitty-gritties of this bill can be dug out and fixed in a joint select committee of both houses, Madam Speaker, independent senators and as well as our house. Madam Speaker, the Cannabis Licensing Authority, it speaks to the control of cannabis and the handling of cannabis, the issuance of license, the people who are supposed to be on the board, and etc. as a corporate body for regulatory control of the handle of cannabis under the Act. Now, Madam Speaker, this is good, but this needs a joint select committee also. Because you see, Madam Speaker, there's a lot of things in this authority that needs to be fleshed out. Because I remember...
Honourable Member for Barata Sawan, your original speaking time is now spent. You're entitled to 15 more minutes to wind up.
Thank you, Madam Speaker.
Please proceed.
Thank you, Madam Speaker. Madam Speaker, we had a procurement authority. The procurement authority has not yet been fully workable. We had, as Minister of Health, when I was Minister of Health, we had I think it was the National Ambulance Authority. That was a nightmare to set up. And I think they have the data authority. An authority is not a very easy thing to set up and start working, Madam Speaker. It's not easy. And this authority controls, as they say, the total movement of cannabis throughout the system. Now, it goes and it talks about, in fact, this one talks about THC, tetrahydrocannabinol delta 9, the active ingredients in cannabis, and one of the many natural occurring chemical compounds found in cannabis. Imagine in the authority, Madam Speaker, the definition of THC is here in bold, and but it doesn't talk about hemp, etc. It just talks about the THC levels. Madam Speaker, I just want to go to one part of it in the short time I have, because this was the whole idea behind movement and decriminalization of marijuana, Madam Speaker. Medicinal marijuana. Medicinal use of marijuana, Madam Speaker, for medical purposes. It started off, I remember that a young girl had spastic syndrome, I think it was Gaucher disease. And no matter what she was given, nothing was working. And the mother begged one of the doctors to let her try the cannabis, the medical marijuana. I mean, that was basically illegal at the time in the States. And the doctor found a way through the FDA or whatever to give it to her, and the spasms stopped. This girl was getting spasms like every 5 minutes, like a neuroleptic kind of disorder. And then it started to be used, Madam Speaker, for chronic pain. Then it started to be used for vomiting and upset feeling and nausea in chemotherapy, and it worked. It started to be used for chronic asthma, so it's called, and also status epilepticus with constant epilepsy. And it started to be used in small quantities, Madam Speaker, for sleep disorders, for depression disorders, psychological disorders. And if you understand the concept of homeopathy and Ayurvedic medicine, homeopathy uses toxic substances in small quantities to get a positive effect. Toxic substances. You could use, Madam Speaker, something called snake venom, lacasis, and it works very well on muscular spasms. And that is basically the whole idea about homeopathy. It works according to the person's body. So what may work on me may not work on Dr. Lee or work on Minister across there. It wouldn't. It all depends on how you use it. So this is the same thing with medical marijuana. It works on the same principle. It's a plant, and the medical aspect of it is low doses for maximum effect. High doses, Madam Speaker, will send you into never, never land. Like people may say a glass of alcohol or a glass of wine will soothe some people who are feeling down, but 5 glasses will make them drunk and over the count. It all depends on the quantum that's being used. So, yeah. So, Madam Speaker, the section part 5 of the Cannabis Licensing Authority says in section 43(1), a person who uses medicinal cannabis without being authorized to use medicinal cannabis by a prescription or recommendation from a medical practitioner commits an offense and is liable on conviction on indictment to a fine of $100,000 and to imprisonment for a term of 10 years. 10 years. you're using something which is going to help you because you have nothing else to use, and you could be subjected to a fine of $100,000 and imprisonment of 10 years. It's a bit draconian. Madam Speaker, these are things that need to be fleshed out in a joint select committee. You see, Madam Speaker, medicinal cannabis, what is the THC content of the medical cannabis? It has not even been worked out worldwide. You don't know what's the strength of the tablet, what is the strength of the pharmaceutical preparation. You don't know what strength is going to use for what. And as I said before, different people use different strengths of items to get the same effect. If this lady with her child was living in Trinidad and Tobago with that status epilepticus, she would have been, and she got caught by, unfortunately, subjected to a fine of $100,000 and 10 years imprisonment because she used something that was thought to be useful for her baby to get better. You're subjected to this. There have to be some sort of amendments to this, or something that you could put in a joint select committee, Madam Speaker. We talk about medicine. We talk about a person cannot use medicinal cannabis without a certificate in writing from a medical practitioner certifying the use of medical cannabis, etc., is necessary in the case of that child. Madam Speaker, a medical practitioner, according to this licensing authority, is any doctor. Once you have a medical degree, you could do it. Once you have a pharmacy degree, you could do it. Madam Speaker, this is a specialized, this is new research. This is new things coming up, Madam Speaker. You have to have medical doctors and pharmacists who are specialized in some form or fashion in dispensing these items and also in knowing more about the items and the effect of it. Research. It is, you know, and then you talk about in individual doses, 30-day supplies, etc., Madam Speaker. This medicinal part of the Cannabis Licensing Authority is what the Honourable Leader of the Opposition has been very interested in making sure could happen. And we need to send this to a joint select committee, Madam Speaker, so we can start working out a proper plan totally, Madam Speaker, for medical, the use of medical, I was about to say marijuana, but is medical cannabis. Cannabis, Madam Speaker, has to be changed in this. You cannot use the word cannabis in both bills because you are subjecting people to an unnecessary criminalization of things that don't have the criminal effect in it. The THC, Madam Speaker, is what is responsible for the dangerous drugs and also the good effects. Imagine that. The same thing that was going to kill you helps you. Depends on the quantity, on the concentration. Madam Speaker, it goes on, and I've written a note here. A pharmacist should not dispense to a patient where applicable a quantity of medicinal cannabis greater than that which the parent or carer is permitted to obtain under prescription. And you have to go on a prescription every 30 days. Madam Speaker, we need to start looking at the research capabilities of the cannabis. There's also part 6, section 48. It talks about cannabis for religious purposes. And it doesn't mention anything, Madam Speaker, about what religious organization, Rastafarian, which one you're talking about. And a person who contravenes a religious organization is permitted to handle cannabis under a license, shall not handle or permit the handle of cannabis for any type of commercial benefit, etc. But as Jamaica has for events, and they contravene, if they contravene it, $10,000 and 6 months. Madam Speaker, the penalties for this thing, Madam Speaker, is extremely draconian and needs to be looked at and fleshed out in a joint select committee. The authority, Madam Speaker, is an authority that they said in the definition, the preliminary part 1, cannabis means all parts of any plant of the genus cannabis, including any resin obtained from that plant. Madam Speaker, when you use the word any and of a genus cannabis, what you are doing is saying that this encompasses hemp. It encompasses hemp as well as CBD, as well as all cannabis plants that have low concentrations of THC. Cannabis material means cannabis, cannabis resin, and any raw material derived from the cannabis plant. CBD oil for medical uses, Madam Speaker, is derived from the cannabis plant, and it has a THC content of 1%. Madam Speaker, these legislation need a lot of work, plenty work. I am not a lawyer, Madam Speaker, and I can see that. We need to send this, Madam Speaker, to a joint select committee, and I actually beg the members on the other side, if they could at least convince the Attorney General that we would like to have this sent for proper drafting, proper flesh out, proper assessment, and a proper bill to be brought to this honorable House where we can move forward, Madam Speaker. We can move forward with cannabis legislation, decriminalization. We would like to see the decriminalization of the marijuana for the benefit of those who are in remand yard, who have already served their sentences and cannot find the money to get bail to come out or whatever it may be. Madam Speaker, in the legislation with the dangerous drugs, after the person is released, they have to apply to attorney at law through the attorney at law to the Commissioner of Police to have that offense expunged. Madam Speaker, we ask that they don't necessarily have to go through attorney at law, because some of them mightn't have the money to pay an attorney at law. And legal aid is a little difficult to obtain. And if that offense it has to be expunged from the record, why can't it be expunged from the record when the person is being released? Rather than having to go through an attorney at law after you're released, if you are convicted from less than 10 grams of resin or 60 grams of cannabis, while they're releasing you, Madam Speaker, why can't they just expunge it out? Rather than you have to go through an attorney at law and the Commissioner of Police. Madam Speaker, I believe that it is important to get the legislation right, because it's new legislation. It's very new legislation. It has been done in different, and I personally like the Jamaican model. It's not very oppressive, and it gets the point across, Madam Speaker, and you talk about the ounces and whatever maybe. That is a legislation that we should look at. And also in the Jamaican legislation, they place the cannabis, I think, license authority in the main bill of the dangerous drug bill, rather than having a separate bill for it. And it covers the same things that we have here. It's just a matter of tweaking the dangerous drug bill, defining it properly, and putting a proper system in place, Madam Speaker. And we do have, in both houses, people who can do that pretty well, rather than having it singularly here and singularly there. Madam Speaker, with those few words, I would like to thank you very much.
Thank you very much, Madam Speaker, for recognizing me as I rise to make a contribution as we debate two bills. Bill number 1, a bill entitled An Act to Provide for the Regulatory Control of the Handling of Cannabis for Certain Purposes, the establishment of the Trinidad and Tobago Cannabis Licensing Authority and connected matters, and Bill number 2, an act to amend the Dangerous Drug Act, Chapter 11.25. Madam Speaker, I just want to give way to the member for Barataria Sawa for 1 minute, because I have a lot of regard for him, and I don't want to misquote him. Did I hear you say correctly at the start of your contribution that the leader of the opposition is in favor of medical marijuana only?
Yes, but most likely she was medical marijuana is on the basis of the whole thing.
Okay.
But she's in favor of the whole, everything.
Great. Thank you very, very much. Because I was a bit confused, because on November 10th, 2019, the honorable member for Siparia is quoted as saying that she proposes legal ganja legislation. Again, Kamala proposes a brighter future for TNT. Plans include decriminalization of marijuana. So I was a bit concerned, and I'm glad you clarified that. Madam Speaker, my good friend, member for Barataria Sawa, went into a lot of details as to why this should go to a joint select committee. I want to ask the member, when you look at the Motor Vehicle and Road Traffic Act, and you look at the amendment that was made to Section 70, where it said the act is amended in subsection 1 by deleting the words drink or, and B, by inserting after subsection 4 the following subsection 5. For the purposes of this section, drug includes intoxicant other than alcohol. So what the Attorney General was telling me while you were speaking is that the issue of drugs other than alcohol being tested for in Trinidad and Tobago is already on the books. But he will reply to you in fuller detail. I just want to draw your attention to that amendment. Because you see, it makes a mockery of the work done by forensics for decades in this country. Madam Speaker, the member also spoke about why people who are being released have to go to legal aid and so on. I think the Attorney General was pellucidly clear when he quoted the Privy Council case, which more or less spells out why that can't happen. So we have to rely on the Privy Council ruling that this thing can't be done en masse, they have to be done individually. Madam Speaker, the member also made a lot of heavy weather about the use of medical marijuana. And I want to say up front, the benefits of medical marijuana are well known. But when you are doing something novel, innovative for the first time, one must tread lightly and carefully in the medical fraternity. I'll give you an example. Back in the 1960s, there's a wonder drug that came out called thalidomide. Yeah, remember for Oropuch East. A wonder drug that came out called thalidomide. And because it was not controlled or managed in those days, thalidomide is a common name. It was used for morning sickness and pregnancy and prescribed around the world. But because there were no controls on it, because there was no history of its usage, because there were no serious clinical trials, because there was no body of experience and what we call post-market surveillance after you bring a new drug to market, you know what they found out years after? Millions of babies born around the world with limb deformities. Traced to what? Thalidomide. If the world had listened and tread lightly and carefully when we are using new drugs, I think the member for Barataria Sawa may wish to reconsider that. So we have to tread lightly with marijuana because I'm going to talk significantly about marijuana and pregnancy as Minister of Health. So we have to tread very, very careful. And don't think that the thalidomide issue did not happen in Trinidad and Tobago. When I went to a wheelchair distribution ceremony with Hannah Janura last year, I met thalidomide babies, now in their 40s and 50s, born in Trinidad and Tobago. So it's a very real issue. You must tread lightly with novel drugs. Madam Speaker, I am going to speak on both bills. The Honorable Member for Barataria Sawa did not speak on the Dangerous Drugs Amendment Bill. But before getting there, I want to thank especially Senator Clarence Rambarat, who is the chairman of the Legislative Review Committee. He did a wonderful job in chairing the committee. The Attorney General for his input, the different ministries, the Ministry of National Security, the Ministry of Agriculture, Lands and Fisheries, Ministry of Health, the Office of the CPC, and every technocrat who sat with us for many, many hours. Madam Speaker, I will start with Bill number 2, which is an act to amend the Dangerous Drug Act and the schedules. So for the lay person listening out there, I want to explain how we come up with these schedules. You have what are called drug schedules, 1 to 5. WHO sets out certain criteria as to what drug goes into what schedule. And it is determined by the usefulness of the drug, the propensity to cause side effects, its safety profile, its ability to cause dependency and addiction, its medical usage, and its psychotropic activity. So, for example, the most psychotropic addictive drug will be the most controlled drug. But how is drug scheduling done in Trinidad and Tobago? Under the Ministry of Health, we have 3 pieces of legislation that speaks to drug scheduling. 1, the Antibiotic Control Act, not relevant for what we are doing here. Chemistry, Food and Drugs, which has schedules for controlled drugs. For example, everybody knows the drug Valium. It belongs to a class of drugs called benzodiazepines. So Valium, Ativan is a controlled drug under the schedule managed by Chemistry, Food and Drugs. Under Chemistry, Food and Drugs, there are other schedules. The 3rd schedule, antihistamines, the public knows about, especially now with the flu season, Piriton, Benadryl. And all the non-communicable diseases drugs, the glucophage, the metformin, enalapril, and so on. That is under Chemistry, Food and Drugs. Then you have OTC drugs. Example, Panadol, paracetamol. And by the way, Madam Speaker, to tell you how different countries use different rules for scheduling of drugs. Do you know in the United Kingdom, you cannot buy more than 20 paracetamol tablets in a drugstore? You cannot buy, but in Trinidad, you could walk into a drugstore and buy 1,000. You could pick up 10 bottles of 100 paracetamol off the shelf of a drugstore. But you can't go to Boots in England and do that. You can only buy 20 because of its ability to cause liver damage, and it is used for suicide. So different countries work their schedules slightly differently. We are here today to talk about the 3rd piece of legislation, the Dangerous Drugs Act, which has 5 schedules. The 5th schedule of the DDA, Dangerous Drug Act, speaks to enforcement powers. The 4th schedule contains certain drugs. Let's take a drug like codeine, linked as codeine you take for a cough. That's in the 4th schedule, and certain precursors. Precursors is mentioned in this piece of legislation. The 3rd schedule does not speak about drugs. That has to do with the Interpretation Act and enforcement powers. The 2nd schedule, psychotropic drug, and the 1st schedule, narcotics, which is what we are here about today. So I have painted a picture of the 3 pieces of legislation that touch and concern scheduling of drugs. We are here to talk about the Dangerous Drugs Act, not the Antibiotics Act, and not Chemistry, Food and Drugs. So bill number 2, that's what we are here about today. Why do we need to amend bill number 2? Reason being, Trinidad and Tobago is a signatory to 3 main international drug control conventions, and we have to list them for the Hansard. 1, the Single Convention on Narcotic Drugs of 1961, as amended by the 1972 Protocol. 2, the Convention of Psychotropic Substances of 1971, which is what we are here about today. And 3, the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances, which is why we are here today. What are some of the policy objectives, Madam Speaker? We have to update our laws as we go along. The proposed amendments aim to schedule new drugs that are currently in use in the country, both drugs used for legal purposes and drugs used for non-legal purposes, like the ecstasy pills, the green Heineken pill. Another one is called the, let me give you the street name, Madam Speaker. This street name might mean something to some people. I will come to it soon, the blue something pill. So what we are doing, these legislative changes will bring Trinidad and Tobago into compliance with the Controlled Drugs as identified by the International Narcotic Control Board. The first and second schedules of the DDA, which I explained what it is, may be amended by order by the Minister of Health. Done. The fourth schedule of the DDA may be amended by order of the Minister of National Security in accordance with Section B of the DDA. Minister of National Security has done that. Done. The food and drugs regulations may be amended by the Minister of Health in accordance with Section 25 of the Food and Drugs Act. Done. So we have done all of these things. The rationale behind amending the Dangerous Drug Act now has to do with the fact that the Trinidad and Tobago Forensic Sciences Center has noted the presence in our landscape, especially our party landscape, of a number of psychotropic substances, plant-based substances, that are now used by lots of people in their 20s and 30s, drugs which are derivatives, so I have to give the chemical name, methylene, dioxymethamphetamine, and I will refer to it as MDMA from now on, commonly referred to as ecstasy or Molly. And these drugs have little or no therapeutic effect, but they are used to get high. As a result, it is recommended that these new psychotropic substances to be included in the DDA, Dangerous Drugs Act, to capture new and emerging drugs which were not previously listed. So we are updating our DDA to protect the population from these dangerous psychotropic drugs. Further, the psychotropic substances such as ketamine, which is used in both human medicine and veterinary medicine, can be abused. So we have to reschedule that. We also have to reschedule methamphetamines and another class of drugs called cathinones. Cathinones are a plant-based drug, but is now synthetically made. Unfortunately, it has little therapeutic action, but significant psychoactive and addictive features. It resembles something called ephedrine. Everybody knows what ephedrine is. It stimulates you. So we have to bring in all these new drugs into the DDA, and that is why we are here today. Madam Speaker, science, and especially the illegal part of science, has a way of outstripping legislators. We now have to include in our DDA amendments, Dangerous Drug Act amendments, something called analogs of drugs. What is an analog of a drug? You can have a drug. Let's take, for example, fentanyl. Fentanyl right now is causing a massive opiate crisis in the United States. People are dying by the hundreds of thousands. But what the drug pushers do to get around how fentanyl is classified, they tinker with the molecule and derive something called an analog. It's the basic molecule, but the other chain here, other atom there. But it's chemically and psychotropically similar to fentanyl. But if you only list fentanyl on the DDA and don't include its analogs, in the future, you will have to come back to Parliament every 2 days to amend the act to include a new analog, which is making the party circuit. So what we have done under the proposed amendments is that the first schedule of the DDA, which is the most controlled schedule of the DDA, will now include analogs of fentanyl. Unfortunately, fentanyl is often mixed with drugs like heroin, and it is a serious public health concern in the United States. As a matter of fact, it's an election campaign issue in the United States. So that is why we are including analogs, and the public needs to understand that. What we are also amending in the second schedule, the last time this schedule was amended was in 1991, has not been amended to date. This schedule will now include MDMA, which I spoke about earlier, and other psychotropic substances to include ecstasy, ketamine, cathinones, and now for the street name, which the public might find amusing, blue Punisher pill, whatever that means, and green Heineken pill. That is a street name. Yeah, I see my league leader. I didn't look at you when I said it. I just mentioned it. So blue Punisher pill and the green Heineken pill, the chemicals used in that will now be trapped in the proposed amendments to the second schedule. So we are here to really protect the public from itself by amending these schedules. We are amending the fourth schedule by including 6 substances, and I will go them slowly for the Hansard. ANPP with 2 above, APAAN, APAA, NPP2, PMK glycidate, and PMK glycidic acid. These are all drugs which are controlled internationally, and has been proposed for inclusion under the 4th schedule. When we do this, we will be compliant with our 1998 INCB, International Narcotics Control Board Convention, which we are signatory to, which I started off my debate on. Why is this important? These drugs are what you call precursors. What is a precursor? A precursor is a drug which you can use to make a narcotic as a final product. So the actual precursor might not be the narcotic, but you don't want the illegal drug traffickers to get hold of precursors. So we are including precursor chemicals in all of this. So that is where we are as far as my contribution for the past 15 minutes to deal with the amendments to the Dangerous Drug Act. I hope I have been clear. I gave the 3 pieces of legislation under the Ministry of Health, which deals with drug regulations, Antibiotic Control Act, Chemistry, Food and Drugs, and Dangerous Drugs Act. Madam Speaker, I now turn to the other piece of legislation, which is the piece of legislation to set up the regulatory authority. Madam Speaker, the issue of cannabis, its use, pros, cons, is a very emotive one globally. It's a very emotive one amongst the scientific community, researchers, policymakers such as ourselves, activists, and I see we have some in the gallery, religious leaders. It's a very controversial topic. And as the AG said, you can't please everyone with this piece of legislation because everybody has a hardened view which they can support. But we as policymakers have been looking at this since the AG said since 2017. So what are we here to do today? We are here to look at several things under the piece of legislation. Medical marijuana. So let's talk a little bit about that. There is no doubt that medical marijuana has now found its way into mainstream medicine. There is no doubt there are serious benefits to be had. For example, in the management of chronic pain, in the management of nausea and vomiting in patients undergoing chemotherapy, in the management of seizures, in the management of eating disorders, in the management of tremors. Absolutely no discussion about that. It has been proven. However, the public needs to understand that we are grappling with an issue that is engaging policymakers around the world. And I just want to take off where my friend from Barataria Sawa left off. We speak about cannabis sativa and cannabis indica, or any of the newer varieties. So there's a new variety called Charlotte's Web. Charlotte's Web is that variety which a young girl, Charlotte, I forgot her surname now, is using to manage her seizures. Fiji. This young girl will get a seizure almost every 5 minutes. And there's a video of her, and it's distressing. No parent wants to see their child like that. And there was a group of 5 brothers in Colorado who they went to, and they formulated a blend of CBD, now named Charlotte's Web after Charlotte Figi. So when we are talking medical marijuana, we are not necessarily talking about TCB, which gives you the high, which is psychoactive. THC, sorry. We are speaking about CBD mainly, which is non-psychoactive, and where the majority of the positive medical benefits are to be derived. You also have CBN. We're not going to go down that road as yet. Irrelevant for this debate. What is happening now is that there are more and more clinical trials being done on derivatives of CBD that are coming to market. For example, I gave you the example of Charlotte's Web to manage that girl's epilepsy. There is now, for the first time, an FDA-approved drug called Epidiolex. But I want people to understand that medical marijuana and its positive uses, just like I gave the example of thalidomide earlier, we should not jump on the bandwagon and think it's a cure-all for everything and we go down the road of medical marijuana. It needs more research, it needs cautious use, and that is why the legislation is crafted the way it is. So my friend Barataria Salma would have mentioned the 30-day limit. I don't want to have, in Trinidad and Tobago, the equivalent of thalidomide babies being born if we don't manage how we use medical marijuana. I don't want that. I don't want that. Because I have seen firsthand thalidomide babies in Trinidad and Tobago who are now 40 and 50 years old with no arms and no limbs. Let's not go down that road. So Epidiolex, which is used for limited, approved for limited, this is the key word, limited usage in 2 serious types of epilepsy, Dravet syndrome and Lennox-Gastaut syndrome. They are not a cure-all for all types of pediatric epilepsy. That is the caution I want to put out into the public domain as Minister of Health. Madam Speaker, I now turn to the issue of pregnancy and medical marijuana. And I want to rely on what I said earlier about thalidomide and pregnancy and thalidomide babies born in the 1960s who are still alive today. All pregnant women, all doctors should be cautious when they are prescribing any drug to any pregnant woman, whether it's cannabis, whether it's phenobarb, whether it's paracetamol, any drug needs to be taken with caution in the pregnant woman. For example, you don't give a pregnant woman aspirin. You don't give a pregnant woman ibuprofen, which is an OTC painkiller. You don't give a pregnant woman thalidomide, it's here, because it can have serious consequences for the baby because these drugs cross what is called the placenta and gets into the baby's bloodstream and stunts growth, both physical growth and neurological growth. So the same caution that we apply to aspirin, the same caution that we apply to ibuprofen is the same caution I am applying to cannabis and pregnancy. This is not a free-for-all to smoke cannabis whilst you are pregnant. It is not. And why do I go down that road, Madam Speaker? Just for illustrative purposes. Alcohol is freely available, but women are not supposed to drink alcohol while pregnant. Why? Because you can get something called fetal alcohol syndrome. What is fetal alcohol syndrome? It causes brain damage. And the babies are born with peculiar facial features, as the member for Barataria Sawa will know, and physical defects. Point again I am harping at is that if and when this legislation is passed, doctors and mothers have to be very, very careful and cautious with it. So the same way we advise people not to smoke and be pregnant, not to drink alcohol and be pregnant, it's the same caution with marijuana and pregnancy. Because the Minister of Health, I'm coming to my responsibilities under this piece of legislation now. A piece of research, pregnancy, marijuana, and other potential drugs of abuse. Worldwide, I have no data for Trinidad and Tobago. We don't have any, I checked. But worldwide, there's a 2 to 5% use of marijuana in pregnancy. That's a lot. That's a lot. It may sound low, but it's a lot. And babies born to mothers who use marijuana, the risk to the babies are increased stillbirths, increased premature birth, smaller babies because they don't grow well in the womb, WHO. Behavioral problems, risk to mothers, permanent lung injury, dizziness, impaired judgment. In Trinidad and Tobago, and this is the data I have for Trinidad and Tobago now, we started something called a perinatal information system. What we have found in Trinidad and Tobago with smoking cigarettes is that we have a 6.6% usage of cigarettes among our pregnant population in the first trimester, and illicit drug use of 3% in the first trimester. That is too high. Smoking, 3.5% in the third trimester. Illicit drugs, 1.9% in the third trimester. And listen to this one, alcohol. Trinidad women use alcohol 4.7% in the first trimester. And that's where the problem is. So I am urging people, the same caution as Minister of Health I put out for not smoking cigarettes, not using alcohol while you are pregnant, is the same caution I put out for marijuana, right? Madam Speaker, I now want to get to the Act and what the Act confers upon the Minister of Health as the line minister for the authority. So Part 2 of the Act speaks to the Trinidad and Tobago Cannabis Licensing Authority. I would not read out the whole thing, it's there, Section 4. There is established a body corporate to be known as the Trinidad and Tobago Cannabis Licensing Authority, which shall be responsible for the regulatory control of the handling of cannabis in accordance with the provisions of the Act. And it goes on to list all the functions in Section 5 from A right down to M. The part of the Act I want to go to, which deals directly with the Ministry of Health, is this. If we go to
Honourable
Part
Member for
5.
St. Joseph, your original speaking time is now spent. You're entitled to 15 more minutes to wind up your presentation.
Thank you very much, Madam
Proceed.
Speaker. Is medical cannabis. I have spoken about medical cannabis. The part I want to speak about in the Act, and I spoke to the AG this morning, this Act ought not to be proclaimed until certain measures are put in place by the Ministry of Health. That's the Control Act. So under medical cannabis, we have to educate doctors and pharmacists, and I think the former Minister Barataria Sawa spoke about that. We have to adhere to some guidelines. There are guidelines out of Australia, the Queensland Health Guidelines, as to how you prescribe medical marijuana. We also have to look at other guidelines. Globally, the gold standard for prescribing guidelines is something called the NICE guidelines, NICE, National Institute for Clinical Excellence, I believe it is. And that is what we have to train doctors now on how to prescribe medical marijuana. How do we register a medical marijuana product that falls under the Ministry of Health? I would have given the 3 pieces of legislation earlier: Dangerous Drug Act, Antibiotics Control Act, Chemistry, Food and Drugs. I am advised by the Chief Medical Officer and the Legal Department of the Ministry of Health, if it is we are registering a narcotic or a psychotropic substance, for example, one that contains THC, that falls under narcotics. That goes to the Drug Inspectorate for registration. For comparators, this will include drugs like morphine. So we will treat the psychoactive part similar to how we treat morphine. If, however, I am advised, it's the non-narcotic derivative like CBD, Epidiolex, which I spoke about earlier, and its derivatives, that goes to Chemistry, Food and Drugs. These systems are already in place. Already in place. I am advised by the Chief Medical Officer. So that takes care of part 5 in summary. The other part, which deals with setting up of the authority, if I could use the analogy to the Children's Life Fund. When we set up this authority, we are going to have to appoint a board, you're going to have to appoint a CEO, you're going to have to develop a business plan, we are going to have our operational build-out, because what we don't want is what happened with the Children's Community Residences, Foster Care and Nurseries Act, which was passed by the UNC, passed by Anand Ram Logan, did not do the necessary work, and when he went into opposition, he sued the state because the children's home weren't ready. We are not going to do that. So the authority and all the licensing provisions have to be set up by the Ministry of Health first. So we have to set up the authority, appoint a board, appoint a CEO, work out our organizational structure, our processes, systems, logistics, and enforcement. And the Ministry of Health will be the line ministry for this. So I anticipate that the Minister of Health is going to become a very popular person when this happens. So, Madam Speaker, in the few minutes I have left, I just want to recap what I tried to convey to the population. We are debating 2 pieces of legislation side by side. One, amendments to the Dangerous Drugs Act. I gave the country the landscape of how drugs are registered under 3 pieces of legislation. I gave the rationale for amending the Dangerous Drugs Act. A lot of it has to do with public protection against the use of these party drugs, ecstasy, green Heineken pill, blue Punisher pill, and all of these things. I gave the rationale why we have to include the word analogs, because you don't want to come back here when you are outsmarted by the drug pushers, when they take a drug, make an analog, which is really similar, by changing a molecule, and have to come back to the Parliament to amend to put that new drug. So we have hopefully worked around that by including the word analogs in the legislation. I am very, very pleased to be part of this government that has seen it fit to bring to the population a piece of legislation, and I want to echo the Attorney General here because I believe it. This piece of legislation will not please everybody. It will not. There will always be somebody who says, coulda, shoulda, woulda, we should have done this way, we should have gone that way, we should not have done that, we should not have done this. But it is a piece of legislation which I think, out of the 4 consultations that the Honorable Attorney General and Honorable Fitzgerald Hines would have had. I went to two. I went to the one in Napa and I went to the one in UE. They were very constructive. As the Attorney General said, over 1,000 people would have participated across the consultations. And it's about, with a whole year of consultations. It's a piece of legislation whose time has come. The Prime Minister and the Cabinet are to be congratulated. And Madam Speaker, I recommend this piece of legislation to the country and to our friends opposite. Thank you very much.
Member for Caroni Central.
Thank you very much, Madam Speaker. I just wanted to ask a question, two questions. If the minister is able to answer, I would be happy. If not, I will just proceed. The first one is whether the Chemistry, Food and Drug Department is fully operational. And then the second one is, given the things that you have to do, and they've given you your caution about proclaiming a bill too early, when do you anticipate that this bill will be proclaimed, especially the one that has to do with the establishment of the board?
So the matter of proclamation will be dealt with by the AG. On the issue of the Chemistry, Food and Drugs. You may remember when I became Minister of Health, the Chemistry, Food and Drugs was shut down. There were OSH issues, the building was decrepit. We are working towards the functioning of Chemistry, Food and Drugs by January. We have spent millions of dollars to refurbish. But the issue of testing, and this is important, not because Chemistry, Food and Drugs is non-functional does not mean that testing of drugs does not take place. It takes place at the Forensic Center, and we could always send drugs abroad to CARFA in Jamaica for testing, as we have done. So the public interest is preserved. Thank you.
So it's not functional, right? But testing can take place. And the AG will say when the bill will be proclaimed. Now, Madam Speaker, there are 7 very important components of this bill. First of all, there's the issue of the decriminalization of possession of 30 grams or less of cannabis, or 5 grams or less of cannabis resin. The bill also allows, that is to say, on the Dangerous Drugs Amendment Bill, the bill also allows for cultivation of up to 4 male plants. The AG has indicated now that it will be any kind of plant. So that issue has been resolved. It imposes a $50,000 fine on someone who is in possession of over 30 grams and less than 60 grams of cannabis. But there is no criminal conviction or criminal record. This also goes for 10 grams or less of cannabis resin. So while the 30 grams is allowable, over 30 grams results in a possible charge and fine. If you contest, as the AG pointed out, you can get a ticket and pay $2,000. But if you contest it and you are found to be wrong, that is to say guilty, you can get up to $50,000 as a penalty. A person with a previous criminal record for such crimes can have his conviction expunged and be granted a pardon. That is a good thing. And the AG made that a particular issue when he spoke. and the member for Sawa Barataria pointed out that that seemed to be the principal driving reason behind it. There's another one, and I will refer to it. So that is one of the things that this bill will achieve. It also adds, and this is the fifth issue that it covers, other dangerous drugs like LSD, ecstasy, and ketamine with stiff penalties for violations, and the Minister of Health spoke to that. Sixth, you can't smoke cannabis in a public place or have it in your possession, because that is now a breach of the law. And you can't have it with you or smoke it in front of children. So these are the 7 areas that are covered, Madam Speaker, by this law. All right? Now, I am happy to see cannabis possession decriminalized. I think it's a good thing, as the AG said, as the Minister of Health said, it was long in coming, because a lot of people have gone to jail for having 1 ounce of marijuana in their possession. And as this legislation attempts to do, all of those people now will now get a reprieve. But there is something about this bill that is bipolar, I find.
I like it. I like that expression.
All right? Which is to say that while it attempts to decriminalize marijuana on the one hand, and to address the issue of large numbers of people in prison who would have obtained a criminal charge because of an ounce of marijuana in their possession or a joint. You also have in this bill, Madam Speaker, some very, very heavy penalties and some really draconian interventions on the part of the law. And that is why I say it is bipolar. And I think the clarity that should inform such a bill, notwithstanding the issue of balance with the AG mentioned, you know, when I walked in here, when I was walking into the entry door of the Parliament building, there were people outside saying no to drugs and no to marijuana. Okay? So that is one position that you might articulate on one extreme. And there are those, of course, who would like to see a total end to the prohibition era in marijuana and therefore advocate for the legalization of marijuana. So that there are extreme positions, and what the AG has done is to try to find, as he said, a balanced course and to find a middle ground, to which we have no objection. But I think in doing so, the clarity and perhaps some precision that was needed to achieve the balance in Act was not there, or certainly did not manifest itself in the bill. Now, I don't know why you would want to charge someone $50,000 for possession of more than 30 grams of marijuana. So I want to go to the other thing, which is that when the AG talked about the bill, he talked about the fact that the prisoners cost $15,000 per person, per day, not per day, sorry, possibly no, I think, was it per month? Anyway, he used the number of $15,000 to feed and basically house them. And he talked about the billions of dollars that ran up. And he also talked about other things in financial terms. And I want to ask if part of the thinking behind the bill was to create a revenue generating measure, you know, and if that is the case, I don't think that this bill or this issue is the place to do it for these kinds of crimes. Either you decriminalize and you open the system, or you don't touch the decriminalization issue. And, yeah.
It's now 4:30, so I suggest that we
Break.
take the break now, and you'll continue after the suspension.
Sure.
Members, it is now 4:30. This House is now suspended for TV shall return at 5 p.m.